within the ambit of that specific matter. So we do engage with the Hawks. In fact, there's a weekly meeting that the head of investigations in IDAC attends with the Hawks so that we are able to synergize new matters and where we are with old matters, and whether or not there might be something in either or agency that the other might need in terms of assistance. But when it comes to matters coming into IDAC, even corruption matters, they have to come in through a referral, which is a Section 27 referral in terms of the NPA Act. And the only other way it comes in is if they are referred to the ID and IDAC through the Office of the National Director in terms of Section 28 of the NPA Act. So had it not been for, do you have those dockets, give them to us, this is corruption. We cannot do that, and we haven't done that. And we cannot also go to the Hawks and say, we want to do this, so give us yours. What does happen is, where the Hawks also have started a matter and they feel that it might be best placed to deal with it in IDAC, there is then that handover and or joint working process. But you cannot just go take a matter. We can't just take over a case, project or docket.
Yeah, I think that explanation is important, and I'm sure will be expanded upon later. But the Director of Priority Crimes, the Hawks, they deal with priority crimes. You deal with serious corruption cases, which would also indicate, or us as members of the public would expect to be dealt with as a priority crime. So you're saying the way you deal with it is you have a regular interaction with the Hawks.
That is correct, Chair, because the Hawks also have a mandate to deal with serious corruption matters. And so that there's no duplication or overlap. That weekly engagement seeks to ensure that that doesn't happen. But there's interagency working where we actually do share resources if they are needed. What IDAC is also able to do, Chair, is if there is a matter in our space, but there's a capability that also lies within the DPCI, we are able to designate those persons into an authorized IDAC investigation. So a DPCI investigator who's not seconded to IDAC can actually be allocated to a matter within IDAC through a designation process.
And we know now from the evidence and from the organizational design structure of the South African Police Services that there are also specialized units. And I think all of us now understand why these special purpose units have been established: murder and robbery, abduction, kidnappings, organized crime, mine killings in the mines, amazamas, and a whole host of specialist task teams, which would also indicate priority and certainly serious crimes. So do you interact at all with those units? And of course, one of those units is the political killings task team unit or task team. Do you interact with those units, or do you act with the National Commissioner and his deputies who are heading those units?
To clarify, Chair, in my earlier days as a prosecutor, yes, the specialized task team that I would have engaged with was what was called the SVC, Serious Violent Crime. They mostly dealt with the cash in transit matters, business robberies, and so on. So that was the one specialized unit most of us dealt with. And that would have been the case even throughout my time at head office as National Coordinator Organized Crime. We dealt with the various agencies that dealt with. So within the detectives, for example, as is with the Hawks, they also had specialized teams. They didn't call them task teams, but they had dedicated teams that would work with extortions, dealt with essential infrastructure theft, which was quite an issue. So we worked with teams that dealt with specialized matters. But the only specialized task team I did deal with was the serious violent crime unit at the time. When I became the head of IDAC, and IDAC itself, we only engaged then in terms of law enforcement in the main with the DPCI, which is the Hawks, with the South African Revenue Services, the Financial Intelligence Center, and we also deal with Treasury when we need to, have engagements with the Auditor General's Office, but we haven't had to work with the PKTT because that has nothing to do with our mandate at all. So there's no engagements with them or the work that they do, Chair.
Okay. We'll come to the PKTT a bit later. Just before we go any further, tell us about your office, the makeup of your office, how many people are employed, in which sections, and perhaps also an idea of the demographics in that office.
Council something to print out, but as an overview, the staff contingent as of yesterday, which includes myself, are 128. And that includes the investigating director, the head of investigations, 2 chief criminal investigators, 4 chief financial investigators, 4 project managers. And then across the board, we have senior and junior financial investigators, criminal investigators, as well as data analysts, and then senior and junior advocates. So it's a total of 128, 63 female, 65 male.
And the demographic breakdown?
I'll be able to, during a break, I do have it on my laptop. I will look at it and I will revert with the exact numbers of the demographics. Okay. And I would assume, you'll correct me, Chair, you are asking about the racial demographics yes. Of the office. That's not an issue. I will present it. I do have it on my laptop. I will just want to give you the exact numbers.
And how are people, personnel in IDAC, how are they appointed? Who appoints them?
So, Chair, there's nothing unique about IDAC in terms of the recruitment process. Bear in mind that we are a business unit in the National Prosecuting Authority, which in itself is a program of the Department of Justice. So the recruitment policy in IDAC is the recruitment policy of government as we follow it through the Department of Justice. You would have to identify vacancies and positions to be filled, and these are then advertised. They are not advertised only internally, they are advertised externally. There's a screening process that gets done outside of my office. It is all corporate services that would do those. Persons are screened to see that they fulfilled the requirements, that they correctly filled in. We still do what they call the Z83 form as a form of employment in government. All of those are done. There's pre-screening, there's shortlisting. And in terms of the shortlisting, demographics play a role, both in terms of gender and color equity. Those are part of the equity principles of the NPA as well as the Department of Justice. So all of those factors are taken into account. A panel is pre-approved. We've got to send an approval for a panel. Also, it has to be constituted in terms of both race, gender, as well as qualifications. You cannot have, for example, myself chairing interviews for a data analyst. I might be out of my depth, but I could chair the interview for an advocate or a deputy director of public prosecutions or the criminal investigators. So we take all of that into account. Our panels are sent through to the NPA's head office, and depending on the level of appointment, some, if not most of those panels also have to be approved in the Office of the Director General of DOJ, as the Director General is the accounting officer of the NPA. And then those panels constitute themselves. Shortlisted candidates are then interviewed, go through a two-pronged interview process, which has also become part of what government requires. Ordinarily, in these kinds of positions, you just had an interview with panelists asking questions and scoring candidates. But where we have, especially the criminal and financial investigators as well as advocates, we have part two of the interview process, where they are either given case theories, scenarios, etc., and they have to then answer those. So there's a written portion and also a question that seeks to determine their level of ethics and integrity in the way they engage with the question. So it's not a different recruitment process. It is a recruitment process that's followed by the department.
Do you, from time to time, chair some of these panels?
Honourable Chair and members, yes, I have. I have chaired panels for Deputy Directors of Public Prosecutions. I have chaired the panel for Chief Criminal Investigators, Chief Financial Investigators. I think that's, could have been the Head of Investigations, but I think that is it. I might have assisted where, oh yes, I do recall, I think late last year, ordinarily when you do the positions for State Advocate or Senior State Advocate, we usually have a Deputy Director of Public Prosecutions chair. The Deputy Director from my office who was assigned to chair fell ill, quite ill, and so in order not to interrupt that process, we sought permission, as we do, that I take over as chair, but it was for a prosecution position.
Now, your husband is also employed in IDEC?
No.
No, not at all?
My husband is at Crime Intelligence, and he's been there from 7 July 2009, when the DSO disbanded. And so many of the investigators, collectors, operational support were also moved. Many of them then were moved to either state security and or crime intelligence, and that is where he found himself by virtue of the allocation of personnel given the disbandment of the DSO. He was never at IDEC.
So, my apologies, I was mistaken, I apologize. So your husband obviously knows and works under Lieutenant General Khumalo, who's the head of Crime Intelligence.
That is correct, Chair. If I remember correctly, Lieutenant General Khumalo became the Divisional Commissioner. It would have been late 2022, but my husband had been at Crime Intelligence from July 2009. But having to work under Lieutenant General Khumalo as the Divisional Commissioner would have been from around about December or so of 2022, whichever date the Divisional Commissioner became the Divisional Commissioner. But he had been at Crime Intelligence well before then. My husband, I mean.
Now, in the complex, serious work that you do as IDEC, you would require more often than not intelligence which would be collected by Crime Intelligence, is it, and shared with you, or do you have your own Crime Intelligence section?
So, Chair, we do not utilize Crime Intelligence unless Crime Intelligence refers a crime threat analysis to us, which is part of the job that they do across the board for law enforcement. So if they had to compile a crime threat analysis that dealt with high-level corruption, organized corruption, and then in terms of the Section 27 referred it to IDEC, we would have looked at it. They hadn't done that to date, but we do not utilize intelligence, Chair. That's where the DSO got into trouble, thinking that intelligence is perhaps something we can do. IDEC will collect information that it can get, and we therefore use the subpoena process in terms of Section 28 that allows us to gather information that we would need to conduct our investigations. So it can be anything, from the banks, cell phone service providers, from the revenue service, from the police, and from any person and or entity or agency that may hold the information that we require, and then we conduct our investigations. But there's no intelligence gathering at IDEC.
But when you issue the Section 28 subpoena, it could or may involve the provision of crime intelligence, which could be restricted or confidential. You would have sight of that. I mean, you, IDEC, not you personally necessarily.
So to be clear, Chair, we currently, if you talk of the intelligence field, IDEC has matters relating to state security, and those arise from the State Capture Commission. We have also had Section 27 referrals from state security. When we request information, we invariably first engage by way of letter or meetings, and when we need them for court-directed purposes, we do issue Section 28 subpoenas. So we are mindful in terms of those, Chair, for state security. We have a legal officer that they have identified that we do serve those on. Our letters, however, go directly to the acting DG or DGs, whoever they may be at the time. When we sought information from crime intelligence, the first time that we did seek such information was with regards the Section 27 referral from Mr. Adams, but that information we then subpoenaed the National Commissioner, given the sensitive nature of documents and information in crime intelligence.
Okay, so we'll also park that for the moment. So within, or rather your husband's role within crime intelligence, there's some allegations, not confirmed by any concrete evidence, that you do or might share information which only he is privy to with you in your role as head of IDEC. What would your response be to such an allegation?
Absolutely not. And I know that for some, it might be, you got to be kidding, girl. It really is. I really hold my oath of office and integrity very important. In fact, when I was to take up the position as the head of IDEC, it became a reality that in terms of corruption matters, at that time when I took office, there were already corruption matters being investigated by the investigating directorate into criminal allegations, corruption allegations of SEPs. My husband was very mindful. We had a conversation about do what you need to do. That's always been how it has been. I don't need information from Mr. Johnson. Mr. Johnson doesn't have information to give. I wouldn't ask him for information. Pillow talk gets people killed. That's something we've never done. And that has just been it. And I know that, Honorable Chair and members, it might sound like such a glib answer. It's the true answer. If that is how you operate, you do not have to worry about a comeback. I am aware of the allegations. I think it's natural human nature for people to think that their 1 + 1 makes 2. Unfortunately, in this instance, it does not. We did not ask Mr. Johnson for any information. He didn't share any information. He won't share any information. And just to be clear, even as I sit here, if my husband is not at the Crime Intelligence head office, in all of the more than 20 years that I'm married to him, and in all the time that he's been at Crime Intelligence, I do not know where his office is. It's not my business. So it sounds simple. It is simple. And we've kept it simple.
Thank you. Just discuss, just briefly, your mandate.
So, Chair, we have set out the mandate.
Yeah, it's from paragraph 20 onwards. So yes. Just summarize it.
But in summary, the mandate of IDEC, Honourable Chair and members, is as set out in Section 7(1)A of the National Prosecuting Authority Act. It is, as I indicated earlier, it relates to serious, high-profile, complex corruption matters. But it also deals with commercial or financial crime cases. These could arise from the commissions, Mpati, Nugent, and Zondo. Also matters referred to by the National Director in terms of Section 28(1)B, and then the Section 27 referrals. And then, like I also indicated earlier, we can also look at common law offenses, fraud, theft, forgery, uttering, and any offense relating to dishonesty. And then there's quite a few statutory offenses, PRECA, POCA, POCTATARA, PFMA, MFMA. So in the main, that would be it. And like I also said earlier, Chair, we also are obligated to deal with the FATF requirements, which therefore deal with the money laundering provisions, which find themselves in the Prevention of Organized Crime Act.
You, at paragraph 23, you deemed it prudent to deal with an allegation made by former Minister Cele that there was no or is no oversight mechanism for IDEC.
That is correct, Chair. I did hear that the then Minister indicated that the DPCI has a judge, and the police have IPID, and IDEC has nothing. When IDEC and when the NPA Amendment Act was passed and came into being in August of 2024, when the bill was signed in May of 2024, part of the provisions was that there would be an IDEC judge. We saw the value therein because we engaged with the DPCI. We had also engaged with IPID. This is also something, now that I think about it, before the bill was passed, the DPCI, SAPS, and IDEC, or the ID at the time, had to engage. Then Minister Cele chaired the meeting. Ministers of Justice attended the meeting, as did the head of the Hawks, then General Labia, the DG and DDGs of Justice, Doc Mashabane and Kale Pillay. I attended as the ID, and the late Advocate Rodney de Kock representing the senior management of the NPA. And there were various aspects that we had to talk about, that we had to have a gentleman's agreement on, understanding what the implication of a permanent IDEC meant. And one of the issues that then Minister Cele had raised was oversight. And we had all discussed it, and as part thereof, in the bill, we requested that there be a oversight mechanism in terms of a judge to oversee IDEC, all complaints relating to IDEC, from the head through all of its personnel. This part of the program had to be dealt with by the Department of Justice, and the Department of Justice has appointed, Chair, as you would see in paragraph 11, retired Judge Takalani Joseph Raulinga as the 24 as the inspecting judge for IDEC, which term commenced on the 11th of October 2025 and is for a period of 5 years. We would have to now engage the honorable judge so that we can work out the operating procedures, etc. But this is a recent appointment. But it was an appointment that was in the making, and the Department of Justice dealt with it. So to be clear, IDEC had no input, nor did the NPA, into choice of judge. The legislative provisions asked for a judge to be appointed, and that falls within the ambit of our minister, and she has duly made that appointment.
So, and that's quite a recent appointment.
That is correct, although it formed part of the legislation that came into effect on the 19th of August 2024. If I may, Chair,
yes.
Whilst this process was being dealt with by the Department of Justice, if there were any allegations against any members of IDEC, they would be dealt with. If there were criminal allegations, they are dealt with as the other allegations against NPA employees are dealt with. They go to the police for investigation. If there were issues that related to security of data, state security would become involved. And where there were issues of misconduct, the NPA has within its ambit also of HR, a unit that deals with discipline issues. And there's also the Office of Ethics and Integrity, where complaints could also have been made, just so that we do not create an impression that there was a lacuna in terms of dealing with issues of criminality and or misconduct whilst one waited for the appointment of the judge.
Does the terms of reference or the mandate of the judge, does it also deal with complaints against IDEC or any of its members, like a sort of an ombud kind of role?
It would operate exactly like the DPCI judge. Any and all complaints, be they from the public and or internally, and that is how we see it would operate.
When would you?
Yes, may we please take Honorable Nwala.
Thank you very much, Chair. Chair, I think the evidence letter did not complete.
Let me welcome you to the meeting. Thank you so much. Good morning. You can go ahead.
Thank you, Chair. I'm happy to be back. I think the evidence letter did not complete the oversight mechanism question. IDEC is established in 2019. The oversight mechanism is discussed in 2024. The inspectorate judge is appointed on the 11th of October 2025, which is less than 30 days ago. Now, from 2019 to up to date, how have IDEC been being oversighted? Where did they report? And all that. I think that's the part that is, I think it's incomplete. Thank you, Chair.
Honorable Ngola, it's much like what I indicated, that in the time that we waited for the appointment of the judge, we worked as is with all the matters within the NPA. Where there are discipline matters, they are dealt with in the disciplinary process. Where it was an issue that related to a presidential appointment, those matters are escalated as they should be to the Office of the President, but there aren't any that I'm made aware of. Where there were criminal allegations, dockets are opened and those would be investigated. And where there might be allegations of compromise of data and information security, we have in the NPA the Risk and Security Division, who work very closely with state security, and those issues would have been or had to have been escalated there. So that is how it did work. But in terms of matters that I became aware of when I started as the head of IDEC or ID in March 2022, we have had disciplinary issues where we've had allegations that arose against, for example, we had an advocate that joined us, but the allegations of corruption and criminality arose from his work at the office of the DPP. However, we dealt with it because we became aware of it. A disciplinary hearing was conducted. The employee was dismissed, and I know that the criminal matter continued in court. I'm not sure how far that matter went, but that was the course of how things were dealt with, Honorable Chair.
Honorable Malem.
Thank you very much, Shane. What is an oversight?
So the Honorable Malema, you ask in terms of the judge?
What is an oversight?
So oversight is where they exercise, so the oversight is making sure that we are doing things within the prescripts of the law and or our mandate, and or in terms of the disciplinary code. That is the oversight as I see it in terms of IDEC and or its employees.
And there was no oversight up until the judge is appointed to deal with oversight. There's no need to be defensive. There was no oversight. That's why now there is an appointment of a judge to make sure there's an oversight, key amongst others to avoid abuse of power by those who are at ADIC.
So, Chair, nothing to defend. I can merely indicate what processes we had in the NPA at the time, from the time the ID was proclaimed in 2019. It had the labor provisions and discipline issues were dealt with there. There are matters where criminal dockets could have been opened, and those would have been investigated outside, either by the detectives or the DPCI chair. In terms of the ethics and accountability, they also fell within the labor division, and then we also had risk and security. So in terms of the general oversight, that was the NPA's mechanisms to deal with the oversight issues. In terms of mandate, Honorable Malema, I'm sure that there would have been criminal allegations that could have been laid by anyone who was aggrieved and felt that IDEC had acted, or the ID acted outside of its mandate, but there wasn't a judge. I do agree with you.
There was no oversight as we have it now. That what we have now was not there.
Correct.
To tell us about labor, to tell us even at the Chisanyama, there is a process of dealing with labor issues without having any oversight. So there was no oversight as we have it now.
So maybe if you'd allow me, Honorable Malema, I agree that we now have a judge. However, we were not allowed to do as we pleased if that is the contention. I can only refer to the mechanisms that were in the NPA that were applicable to the ID and IDEC at the time. But you are correct, we only have a judge now.
We only have an oversight by a judge now,
That
which
is
we
correct.
didn't have.
That is correct.
Thank you.
Yes. Honorable Ngola, are you fine?
No, Chair, we're not. And I take a particular interest in this matter because I'm the chairperson.
Honorable Malema, are you satisfied? Okay. You still want to pursue it, Honorable Ngola?
Yes, Chair. Maybe to put it differently, I'm failing to understand what Advocate Johnson is trying to brief us on. Oversight. The point is, where did IDEC report between 2019 and October 2025? It's about close to 6 years now. What was the oversight mechanism in place at that particular time?
Let's do it this way. Advocate Johnson, the first question is, where did you report between 2019 and October 2025?
Honorable Chair and members, the accountability for IDEC, the head of IDEC reports to the National Director in terms of its work and in terms of that oversight, if we want to use that word. So the accountability mechanism for IDEC at the time is in the Office of the National Director.
Next question.
I'm fine, Chair. We'll pursue it further later.
Okay, thank you so much. SC, you may proceed. Thank you so much.
In the short period that Judge Raulinga has been in office, has been appointed, has he received any complaints? And if so, what are the nature of these complaints?
None that we've been made aware of, Chair.
Do you meet with the judge from time to time? Have you met with him since his appointment in October?
No, Chair, we have not.
Is the public aware of his appointment and where to direct any complaints?
Chair, I can only answer in the following way. Judge has been appointed by the Minister of Justice. I'm not sure what his terms of reference are yet, how they've worked that out, but there should be a public indication of the fact that there is a judge. The judge would have to give us the terms of reference, or they should be published through the Department of Justice by the Office of the Minister or the Director General, because that is where the judge sits, what his terms of reference would be, the complaints mechanism, how they report matters, who reports matters. The judge does not account to IDAC at all, or the NPA, but accounts within the Department of Justice.
When and how would the judge's appointment have been made public and announced in the media?
I am unable to assist, Chair. I'm not aware of what the plans of the Department of Justice are to ensure that the public is aware, but it is a critical aspect that the public should be made aware of, because that talks to accountability. People need to know where to go to if they have any complaints about IDAC or its staff, and what the nature of those complaints and or the format should be for the reporting of complaints to the judge.
Would you be able to comment or not on whether senior members of police management or other law enforcement agencies, would they have been aware of his appointment?
I'm unable to comment, sir.
Can we just deal briefly with your experience in two of the more high-profile matters of former or the late General Jackie Selebi and Mr. Solly Lazarus, and their prosecution for corruption, just by way of short background?
Honourable Chair and members, I deal with it very broad strokes at paragraphs 25, 26 and 27 of the affidavit. And just based on our experience, mine included with criminal cases against the late Mr. Jackie Selebi, and it was also with Mr. Solly Lazarus with SAPS procurement, and now with SAPS procurement matters in IDAC. It seems that when the police, and this is in general, not a specific unit, regardless of which component, invites bids for the procurement of services or goods, many people want to participate because they've come to know that the contracts can be very large, and we've seen that play itself out as well in public. They're lucrative. And in terms of the prosecution and investigation in the corruption matter involving the then Chief Financial Officer of Crime Intelligence, Mr. Lazarus, who currently serves a term of imprisonment, Lazarus demonstrated what I referred to above. And during this process, at the time we were in the DSO, it became very apparent, and this is not passage talk, it became apparent through the investigation that officials had learned that if Mr. Lazarus asked something, people were reluctant to say no, because he was the CFO. If you wanted something, the CFO got it for you. So you didn't stand in the way of the CFO, and I'm talking about at the time. That specific CFO and others came up with several schemes to ensure gratification to and from parties relevant to the entire procurement and acquisition process. As an example, and one of the main charges against the then CFO, Mr. Lazarus, was they procured vehicles, covert vehicles, and vehicles for crime intelligence. Part of that was him ensuring that his kickback was getting vehicles, one of which he got for his daughter, for which he was charged, and one of which he got for his family members. So there wasn't procurement for procurement and procurement for services for its officials to be able to do the work. At that time, in that specific instance, there was always, what can I get out of it? And those were the instances that we were able to actively pick up in relation to Mr. Lazarus.
Then, just to move on also briefly, because you've already touched on it to a large extent, the role of crime intelligence in the whole criminal justice system and how important that is.
So,
That you deal with it at paragraphs 28 to 30.
Chair, we must make no mistake that crime intelligence is integral to the fight against crime. It is something that we've always worked with as prosecutors and investigators, especially in the work that I did in my portfolio of dealing with organized crime matters. The DPCI, when the DSO was disbanded, I would attend a lot of their project committee meetings. That is where they discuss which projects to take on, etc. A continued argument that we always had with the DPCI was, if you do not have a credible crime threat analysis from crime intelligence, it is really difficult for you to register projects. And we say that because crime intelligence is very good at coming up, especially for organized crime, with credible crime threat analysis. And this was at the time when we were dealing with organized crime, which I dealt with up until February of 2022. And so it is so that they play a very important role, Honorable Chair, in that they provide for a system that allows for a very credible report of information, which is called a crime threat analysis. It informs law enforcement agencies across the board about possible groupings and syndicates, their criminal activities, the commodities that they may be trading in, and other relevant information. They also deal with transnational organized crime. And so a crime threat analysis from crime intelligence won't restrict itself just to the borders, but if there was something that we needed to know about these syndicates operating outside of our borders, they made that part of the crime threat analysis. I've said it helped investigators and prosecutors. And crime intelligence, without a doubt, is critical to the fight against crime, especially organized crime. I think the only challenge that was found, and that was only based on the Celebi matter that we did, the matter against Solly Lazarus, there was a matter against one Mr. Richard Mdluli, but I haven't dealt with that matter. As critical as their function is, the key challenge that was found during those investigations is accountability for the use of its funds. And unfortunately, secrecy characterizes the utilization of the funds and the procurement. And like I say, Honorable Chair, this was encountered since the time of the Celebi investigation, and we found that fast forward into the Lazarus and the Mdluli era. So I think out of all of this, one hopes that even with this committee, that one finds a balance between their mandate, how it's executed, protecting its COVID mandate, but still that there be accountability for its funding and funding mechanism. And the reason for that, Chair, is not because we need to know about their money. It helps ensure the accountability mechanism, and so that there's no abuse of funds within that system, whether it is for personal gain or otherwise.
Thank you. Can we just move to Lieutenant General Mkhwanazi? Do you know him? How well do you know him?
I guess well is relative, but I've known him for a long time in terms of knowing of him. But in March of 2020, and for about a period of 3 months, I got to work every day with Lieutenant General Mkhwanazi. It was during the period of COVID. He chaired what was called the National Core Command Group, which was a group of generals from the various police components. There were people from the Department of Health. I represented the NPA, etc. And what would happen there, Honorable Chair and members, is when regulations came out, we would have to sit together to see how they would be operationalized, the kind of standing orders SAPS would send, and the kind of provisions we would have to send to the prosecutors for the prosecution and investigation of certain matters. So he chaired that meeting. We saw him every day. It was very seldom that General Mkhwanazi did not chair the meeting. It was the odd occasion. But he was there. He's very boots on the ground, committed individual. So I've worked with him in that environment. I came to know of him being the acting National Police Commissioner, but Honorable Chair and members, we didn't engage on that platform. And now in my time as in IDEC, we did engage with General Mkhwanazi. In my time as IDEC, when these investigations of the matters that were referred to IDEC by Mr. Adams, out of habit, what one does is when investigators go into a province and they are going to see police personnel, you will inform the police commissioner, provincial commissioner, as do prosecutors when they appear in a jurisdiction of a director of public prosecutions. So investigators would inform General Mkhwanazi that they were in his province, that they were seeing police officials as potential witnesses. They also, one of the investigators also engaged him, Honorable Chair and members, when we needed issues of clarity. And that is as far as the engagement goes. And the last engagement I had personally with Lieutenant General Mkhwanazi was during the month of June. He had called and I was away for work and unable to take the call. When I called back, he said, not urgent, we'll talk when you get back. I guess we both got busy. General then did speak to me on the 2nd of July. And on the 2nd of July, it is when the General indicated that he wanted me to talk to somebody about an issue. He sent me the details, but unfortunately, before I don't call anyone. I usually give it to the head of operations, Mr. Sissoko. But before I could do that, the 6th of July media expose by Lieutenant General Mkhwanazi happened, and that was the ambit of our engagements. Our engagements stopped on the 2nd of July.
Now, he makes reference to one of your investigators, Mr. Brian Padiachi. Can you tell us a bit about that? Or let me just put to you two allegations made by Lieutenant General Mkhwanazi in his affidavit. He says a further condition is that if the accused required anything related to their work, it could only be obtained through the intervention of the investigating officer. This is in relation to Lieutenant General Nkumalo, Senior Investigator Brian Padiachi of IDEC, and then later on he says, having regard to the sensitive nature of Lieutenant General Nkumalo's role, a condition empowering Mr. Padiachi to have any access to crime intelligence information is unwarranted. It compromises state security. Lieutenant General Nkumalo has applied for the bail conditions to be amended, but the hearing of this application to amend has been postponed on numerous occasions. So just in relation to, we're going to deal with Lieutenant General Nkumalo's arrest and the charges against him. Yeah. You deal with it from paragraph 56 onwards, allegations against Mr. Brian Padiachi.
Thank you, Honorable Chair and members. To go back to the assertion that you made, Council, I am aware...
Not that I make.
That General Mkhwanazi makes that you've put to me. The assertion being that Mr. Padiachi would have and be allowed to have access to CI and documents. It is, I think it's incorrectly interpreted. That condition dealt with and mainly because we have witnesses at crime intelligence. And those witnesses had indicated that they had been intimidated and victimized. So the condition for them not going to CI was to ensure that the witnesses were not intimidated. Mr. Padiachi would not have been allowed, to be clear, to access any documents from crime intelligence. We would have had to follow if, after that, one identified that there were documents from crime intelligence that were required. Chair, we would have had to follow the process we had followed initially, which would have been to issue a Section 28 subpoena to the National Police Commissioner. No one would have been allowed to go to CI, engage any personnel, or take on any documents. And when it comes to Mr. Padiachi, it is Mr. Padiachi who, in fact, would call Lieutenant General Mkhwanazi to let him know that he was going to be in his province. It was him who engaged with the Lieutenant General mainly. They met, they would have talked. They had meetings, they had WhatsApp exchanges about Mr. Padiachi going down to KZN and what it is that he would require. And General Mkhwanazi was always willing to assist and or to facilitate. I'm not sure what might have gone wrong, because I'm not aware of anything having gone wrong. But when the allegations are made, Honorable Chair and members, that Lieutenant General Mkhwanazi cannot understand what Padiachi is doing at IDAC. I found Mr. Padiachi at the ID. He had come to the ID and had been sought after by my predecessor, Advocate Hermione Cronje, and he remained then at IDAC. He did undergo a detective course. He has conducted several investigations in his time in the South African Police Services. He wasn't only at crime intelligence. We do refer, Honorable Chair and members, from paragraphs 62.1 up to paragraph 62.3 of specific matters that Mr. Padiachi dealt with as an investigator within the South African Police Services in his time at the South African Police Services. So the assertion that he's got no investigating experience and no one knows what he's doing there is incorrect. He has the requisite qualifications, he's had the requisite experience, and he was at IDAC from sometime in 2021, me having taken office in March of 2022, and has conducted investigations as part of different teams that were doing investigations in IDAC.
Thank you. Honourable Chair, may I just request a short adjournment? There's some, you would have seen some activity, there's some documents that I wish to refer the witness to, and which is not part of Ms. Johnson's statement. Committee members.
That is granted, SC. We will come back at 11:45.
Thank you. Thank you, Honourable Chair.
Thank you. Honorable Breitenbach and Honorable Kolabana to take their seats. SC and Advocate Johnson, are you ready to resume?
Thank you, Honourable Chair, Honourable Members, Advocate Johnson. Yes, thank you, Honourable Chair, for allowing us the adjournment. These documents are on record before the committee. It's just that we were trying to, for the convenience, create a bundle. And so if and when I get to it, I'll refer to the documents in the bundle. But Advocate Johnson, we were last dealing with Badeachi, and I think you've concluded your remarks or comments about him and his experience as an investigator. And he's actually someone that, when you came to the what was previously known as the Independent Directorate under Herman Cronje, he had already been employed there as an investigator.
That is correct, Chair.
Okay. These insinuations about your husband working for crime intelligence,
There's nothing to comment more than it is an insinuation. People are entitled to their opinions, albeit that they are untrue and unfounded. I can take it no further, Chair.
Then again, briefly, just under the subheading IDEC investigations into Mr. Usumuzi Kat Matlala, from page 23, paragraph 69 onwards. Do you want to comment on that?
Honourable Chair and members, I deal with it at page 23 from paragraph 69. And without going into the detail of each paragraph, we received, and in fact we have cases where even the head of supply chain, General Mokoena, is facing criminal charges. We have DNC Bonang Ngwenya also facing criminal charges, as well as several other high-ranking police officials. So there are several investigations in IDEC, to be clear, that relate to police corruption and more so the supply chain and procurement component.
Just to pause there, does it relate, excuse me, perhaps to the tender that was eventually cancelled? The one that was awarded to one of Mr. Matlala's companies?
So the first and only time that we are looking into allegations against Mr. Matlala relates to the 360 million rand tender that was awarded and then subsequently cancelled sometime this year. So there haven't been criminal investigations into him as a service provider. We have criminal investigations against SAPS members and other service providers where the supply chain management processes were circumvented and corruption or fraud or PFMA contraventions took place. So in February of this year is the first time that we got a referral that relates to Mr. Matlala as a potential suspect, either in fraud, corruption, or together with other SAPS officials, contraventions of the PFMA. So we received the referral on the 16th of February 2025. And then through the media, as we paid attention, we found out that Mr. Matlala had been arrested and his phones were seized. Our interest was piqued because the media reports referred to his devices being seized. And so given that one was afraid that for the devices to either they get lost or data gets compromised, We also were not aware of who seized the items. We first went to a judge, got cyber warrants, also search warrants. The matter was, but in that time, we were able to engage the Office of the National Commissioner, and the National Commissioner then indicated that the phones were seized by the PKTT and that he would arrange through Lieutenant General Khumalo for those devices to be made available. During the course of that day, a police official, we assume from the PKTT, availed himself with 2 cell phones in a evidence bag. The cell phones were still on. I'm not sure why they were on, but they were on. We had a cyber expert on standby so that the download of those cell phones and the execution of the access warrant was done properly. The official stayed in the room. The investigators from IDEC dealing with the matter were present. The cell phones were downloaded. They were put back in the bag, handed to the official. To date, what we have is data. We were never in possession, save for the time of the actual download of any of the electronic devices of Mr. Matlala. But during the download process and in the presence of the police official who brought those cell phones, the cyber expert made it clear that there were gaps as it became apparent that data had been deleted. Of course, that would have to form part of his report when he makes his report as to when data was deleted and or that there is information missing. We then got that data. We have continued with the investigation into the allegations relating to the SAPS tender. There are many persons that are implicated, both within SAPS as well as Mr. Matlala and some associates. That investigation continues, and that is how we became involved in that matter. The only matter that IDEC currently is looking at with regards to Mr. Matlala relates to the 360 million rand tender. Other tenders relating to the Tembisa Hospital, Honourable Chair and members, is dealt with by the DPCI, and we are aware of those matters because in these weekly meetings, those matters also do get discussed, and we do have an arrangement that should we require any information that we are unable to procure, they would sort of steer us in the right direction in terms of the Matlala matter, but that hasn't arisen because we were able to deal with the matter as we have it. So that's the only investigation. And that's the only time IDEC has dealt with Mr. Matlala and or had cause to have access to any of his digital devices. It was just 2 cell phones.
Now this referral on the 16th of February this year, where did this referral come from within SAPS? Your statement just says it's a referral from SAPS. Who in particular referred the matter to IDEC?
The head of their risk audit referred the matter to IDEC in terms of a Section 27 referral, deposed to an affidavit, attached supporting documents, and the matter came over to IDEC.
And when would you first be alerted to this, or when would you become involved in this referral, if at all?
So, Honourable Chair and members, when matters are referred, they almost invariably come through one of the chief criminal investigators and or more so through the head of investigations and operations, Mr. Matthew Sissoko. So they would receive the matters, go through the matter at a cursory perusal, see whether or not it's a matter that IDEC can take. They then compile an application, which we call a Section 28 application, for the ID to consider whether or not to authorize an investigation. That is the only time, or the first time, that I then become involved in applying my mind to the matter. Here, the matter was then authorized, And when it is authorized, investigators and prosecutors, etc., are designated to conduct the investigation of these matters, as it's a prosecution-led methodology. But the investigators and the prosecuting team go about determining what taskings, activities, line of investigation, etc., should be followed. It is not for the ID.
So there would first be what sounds like a preliminary investigation that you would authorize?
Chair, for clarity, there are two types of investigations. Usually when we get the Section 27 referrals, it also depends on the level of information and or evidence that is provided. There are times where you can authorize a full-blown investigation, which is a Section 28(1). But in most instances, and to err on the side of caution, the ID is able to declare a preparatory investigation, which is a preliminary investigation. It is allowed in terms of Section 2813 of the NPA Act. And as the investigation progresses and they are able to find evidence of the alleged criminality, and there is more than a reasonable suspicion of the allegations, the team has to bring another application to say, at the point where we are at, this can now be a full-blown investigation. There have been matters, just for clarity, Chair, where we authorized a preliminary. After the investigations were done, there wasn't anything to take it forward in terms of sufficient evidence as part of the investigation, and those investigations can be closed. So it's not automatic. It does not automatically progress from one to the other. It depends on the evidence.
So how soon or when after the 16th of February 2025, when the referral was made, did the request to authorize a further investigation, for want of a better word, was that authorized by you?
It would have been within the month.
Within the month?
Yes, because what happens, Chair, is if they sit with it, they can't do anything with it. They have to have an investigation authorized, albeit preparatory. And what it does, Honorable Chair and members, is there are certain processes that can only be activated. So, for example, the request for bank documents, the request for cell phone data, the request for company documents can only take place once you have a Section 28 authorization, and Section 28 authorizations, therefore, by their nature, allow for the activation of legal processes to obtain information. So they have to do it as soon as they are able to put it together, or else it's a piece of paper you're sitting with. You can't move with it when it's not authorized.
Without,
I just heard you saying on the tender of 360 million, there are a lot of people involved, including police officers and service providers. Is Minister Mutkunu and former Minister Cele amongst the people that you are looking at?
Honorable Chair, it would be irresponsible to mention who potential suspects are till we get to evidence. Honorable Malema, I have learned that you can throw a name out there and then you follow what you think is an investigation path, and it does not amount to evidence. It would be irresponsible. You cause irreparable harm. But what I can say is there are several persons implicated, and regardless of their ranking and who they are, and whether they're public or private officials, as long as there's evidence, IDEC will follow that evidence, Honourable Member, and where we can, they will most certainly be prosecuted.
Maybe let me put it differently. You were able to say police officers, high-ranking police officers. Are there politicians that you are looking at without mentioning names?
That is correct, Honourable Member.
Thank you.
May we proceed? Thank you so much.
Thank you, Honourable Chair. in the referral, this is now in relation to Matlala and subsequently the application, the internal application to you to authorize a further investigation. Can you give us, I know in your response to Honourable Malema now, and one can understand these matters are sub judice and your concern about fairness to the accused persons and a subsequent fair trial. You don't want to jeopardize that. But can you give us some idea of what was in this referral? For example, was there any mention about the PKTT? Is there any mention about General Mkonazi? Was there any mention about Lieutenant General Kumalo?
Honourable Chair and members, not in the documents that we received.
Yes, the referral.
Yeah, not in the referral that we received. We received a referral that talks to irregularities in the awarding of the 360 million rand tender to one Vusimuzi Cat Matlala. It refers to police officials, but General Kumalo, General Mkonazi were not mentioned in that referral. Nor was the PKTT, sorry. It refers purely to the tender process, and other members of the South African Police Services within the supply chain of the South African Police Services, the bid evaluation committee, the bid adjudication committee. That is where it stopped. There's no reference to any of those that you've mentioned, Honourable Chair.
And just again in your response to Honourable Malema, when you confirmed, I think, that a minister or ministers are also mentioned, is it in the same referral?
So, to be clear, it's not ministers that are mentioned. There are allegations that politicians are involved, and so we have to determine who these politicians are and what their level of involvement was and whether that involvement then amounts to criminality. In a lot of them, they also would talk of, for example, other persons affiliated to Mr. Matlala. No names are provided. I guess as one does the investigation, you have to look at who in that entire value chain would have been compromised and or complicit in the awarding of what now turns out to be a tender that ought not to have been awarded to Mr. Matlala.
We looked at the investigation into Kat Matlala, and also you were explaining, we just continue with that from the time you get a referral and then there's an application to authorize an investigation or further investigation. Just expand on that.
So once the investigation is authorized, Chair, whether it's a preliminary investigation or, in our terminology, a full-blown investigation, the investigators and prosecutors that are designated, they sit and work out what the line of investigation is, what evidence or documentation they would require, from whom and where. They have timelines for the investigations, and they will also determine the kind of resources they might require in order to conduct that investigation. And they go about their business. They will engage the ID, for example, if there is something that is required, and given our stakeholder relationships, there are instances where it is better, as we have also done with the National Commissioner of Police. More often than not, we will first write a letter making a request for certain things. So there are instances where, for example, they would come to the ID and indicate what they need, and we rather follow that recourse of writing a letter and requesting information. Of course, then when we need it for court-directed purposes, we then agree with the person, we're going to have to serve you with the Section 28 subpoena, especially for issues of chain of custody and evidence. The investigations will carry on.
Honourable Skosan. Thank you, Chair. I just want to find out the clarity. As you sit there, you just said that there's allegations against politicians, am I right? And as you see there today, you don't even know who those allegations against today. I'm talking about today.
Chair.
I am not saying we don't know against whom. It is irresponsible to be throwing names of persons who might be implicated when the investigation is not yet completed. And so the level of evidence against them might either result in us having to charge and prosecute, or it might be that they are mentioned, but there is no evidence. So the investigation continues.
Thank you, Chair. Honorable Ngola, are you fine? Let's see, we may proceed.
Thank you, Honourable Chair. Sorry, Advocate Johnson, we were talking about your role, if any, in any, from the time there's a referral through to an investigation and then a decision to prosecute, and perhaps the prosecution itself. Maybe you would become involved if it's Oscar Pistorius, but your role in these matters.
So, Honourable Chair and members, once the investigation and prosecution team have concluded the investigation and they have determined that charges can be brought and they have determined against whom, what we tend to do before they put together their charge sheet, or what we also do is we ask them to put together a draft charge sheet, and they would present that matter to myself, some of the other deputy directors of public prosecutions who are not involved in the matter, as well as the head of investigations and operations, Mr. Sissoko. They'll talk us through the matter so that we can engage and discuss if we see any loopholes, if there's suggestions we can make on things that must still happen. But it's a collective back and forth engagement. And once that is done, the team will decide who the lead prosecutor will be. They'll put together a charge sheet. They'll also put together what we call a prosecution memo. And that prosecution memo, Chair, gets sent to the Director of Public Prosecution, in whose area of jurisdiction the matter will appear. Because in terms of the NPA Act, the investigating director enrolls after consultation with the Director of Public Prosecutions of that specific jurisdiction. So we send through the prosecution memo, they apply their minds. DPP will usually send a letter to say they have gone through the matter, you may go ahead. And then we enroll the matter as other criminal matters do in the normal course of NPA matters. And they run through the court system.
So, also just to be clear and understand, do you authorize the prosecution of a matter referred to IDEC, or is the decision to prosecute the matter with the DPP in a particular province, or does the DPP just enroll the matter for a criminal trial? So
the investigating director and all the prosecution staff in IDEC have a delegation and mandate to institute prosecutions for and on behalf of the state, similar to any of my counterparts in any of the other NPA offices and divisions. So it is not seeking permission to enroll the matter. It is to inform the DPP that we will enroll the matter in the area of his or her jurisdiction. However, what has happened is they can ask clarity from that prosecution memo. One or two have, we respond thereto, and then they indicate they are satisfied. But the institution of the prosecution happens by the lead prosecutor in the team. What the ID will do is, in going through the charge sheet, would approve that, yes, this is a charge sheet and that it can go to court. Honourable Chair, I think this hands.
Honorable Nomvalo.
Yeah, no, thanks, Chair. Advocate, I just want to be clear on this aspect. Does a referral only require you to prosecute? Do you not face instances where, for instance, a referral will come with evidence which is not complete, which requires you to do more investigation in order for you to establish prima facie evidence? Is it always the case that it requires you to prosecute, it comes with prima facie evidence?
Honorable Nomvalo, no. When the referral comes, investigation must get done. So an investigation must first be declared in IDEC, and the investigation must be done. So even if we are given a referral with what others might consider substantial evidence, we have to declare an investigation. We have to check that that evidence is correct. We have to go back and talk to those witnesses. We take supplementary affidavits if we need to. We conduct further investigation, and only then do we prosecute. So a referral does not allow for an immediate prosecution. A referral allows for an investigation first. Even if we were given a docket, Honorable Nomvalo, we would have to first authorize in the IDEC space, and investigations must happen, albeit just to verify. We cannot just run into a prosecution.
I'm okay, Chair.
Let's proceed.
Thank you, Honourable Chair. We just needed some clarity because you talk about the team, the investigating team, and now the prosecuting team. The matter is discussed. The matter is discussed. But what is discussed? Are you discussing whether there are prospects or what the prospects are of a successful prosecution? Or do you discuss matter, or is it already determined or decided by the lead investigator, lead prosecutor, that we are going to prosecute, and now you come in as the head of IDEC to discuss various aspects of the prosecution where you may require further evidence, additional evidence to strengthen the case or whatever? Just to understand your role in these matters.
There's no separate teams. A team will comprise of a deputy director who would lead the team, and there's chief and criminal investigators. There's a project manager who will manage. There can also be data analysts. And if we need external service providers are also designated to the matter. So at the stage it comes to the ID and others for presentation, it is for the team to present their evidence, what the allegations are, what evidence they have to support those allegations, any challenges they may have encountered, what it is they would require from the ID or the head of operations, or having given us that brief, evidence, charges, what supports it, what's the next steps, that they are now ready, they would like to have the matter enrolled, and then the administrative processes start. What they would need from the ID is to indicate once they've provided a charge sheet and the prosecution memo is that the ID approves that they can go ahead, but then we have to engage the office of the DPP first.
Have you, or do you, or can you interfere with that process of prosecution? And are there instances, have there been instances where when the case was presented to you, you, for good reasons or for no reason, decided no, this matter should not proceed to prosecution?
Honourable Chair, I cannot interfere in a decision, but I have to apply my mind to the evidence, to the allegations, what it is they want to do. We make proposals. Sometimes there may be more evidence that we can point them to, and that is what we do, and we advise on the matter. there has been one or two instances, like I indicated, where you have a preparatory investigation. And when you go through what they present, it's insufficient for a prosecution. Then that decision is made in consultation with that team. I don't sit on my own and say, no, this is not going to work. We're not going to allow this. There's an engagement, and when the team knows and understands, the team will then send a closure report indicating that for these reasons, we make the proposal for the matter to be closed. It's also done in a formal way.
Is there some inbuilt internal mechanisms to review any decision you might make? Or are there instances where it has happened?
So the review mechanism is where, for example, what we do have, and especially in matters that have gone to court, accused persons have the right to make a representation. They will make a representation which would first come through the prosecuting team to the ID. If that representation is unsuccessful, as is with every other matter in the NPA, they have a right of review through the Office of the National Director. So there are review mechanisms to that decision. And in that representation, they can indicate why they believe the investigating director and directorate made the wrong decision to prosecute, and they can provide the necessary evidence which would have to be taken into consideration by the National Director. I think at this point that function in her office is also delegated to the Deputy National Director of the Prosecution Services. At this time it's Advocate Mzinyati. Previously it was the late Advocate Rodney de Kock. But there are review mechanisms that are applicable to prosecutions across the board.
And just because I think it is quite an important matter that was raised by Honourable Malema in relation to the judge, the overseeing judge. Would a matter that has been referred on review to the NDPP's office, and where that office concurred with a decision not to prosecute the matter, would such a matter, in terms of the mandate of the judge, go to him, or can it be referred to him?
I'm sure that it can, if what the persons allege might be a malicious prosecution, a compromised investigation. Those would therefore talk to the integrity of a prosecutor and or an investigator. And of course, I see no reason why it shouldn't go there for the judge to apply his mind. And whilst you're on that point, if I may, Honourable Chair, on that oversight question, the Parliament has been the oversight body of the NPA and therefore IDEC by its nature. So over and beyond the steps that I mentioned of bodies in the NPA. So that's the oversight. But I take the point that the Honourable Malema makes. We only have a judge now. And it is in this process that one is going to be able to determine the value of having this kind of different oversight mechanism that hasn't been a feature of the NPA before, and only because we have investigators and prosecutors under one roof in one agency.
Now, there's also an office in the NPA that's been established. I think, forget the full name, designation now, but the Office of something integrity.
Is ethics and accountability.
Ethics and accountability. Would that office have oversight responsibilities over the work that IDEC does?
They would have had up until the appointment of the judge. All complaints that relate to IDEC must go outside of the NPA to the judge who's been appointed. So the NPA does not oversee those allegations. The NPA will still, I guess, of course, look at misconduct issues, which are labor issues, but complaints against IDEC officials will go to the judge designated.
Okay. Now, just to get a bit closer home to the matter that we're dealing with specifically and to the allegations of Lieutenant General Kumalo, he says in an affidavit that has been placed before us that despite its mandate and the way you've described it, IDEC has elected to involve itself in labor matters. And he refers specifically to the arrest of Lieutenant General Kumalo on the 28th of June, 2025, along with 6 senior members of management on charges of corruption relating to the irregular appointment of Brigadier Makwele, and the records a Brooklyn case number. It is important to note that
Sorry,
under
Chair,
normal circumstances, irregular appointments are addressed through established human resource procedures. In this instance, however, the members of the selection panel responsible for Brigadier Makwele's appointment were arrested and formally charged. The peculiar exercise of criminal jurisdiction over a labor matter warrants further scrutiny. And then he says, I was further informed that members of the PKTT have been the subject of several unwarranted cases as a result of their work. Although the cases themselves are without merit, they serve to distract members and instill fear and undermine the team in the eyes of the public. And then he records certain cases, referring to December 2024, the accused, Usumuzi Matlala, was advised to open a false case against members of the PKTT. Then there was also a case opened by Ms. Fundiswa Nyalungu, the partner of accused Mr. Katiso, KT Molefe, and by 2 of his nieces. It refers to the case numbers. In January 2025, Captain Magotloi, a ballistic expert with forensic services, opened a kidnapping case. And during April 2025, Brigadier Shabalala from the DPCI head office initiated a case, Eastern Cape case, involving allegations of theft under the Corruption Act. So that is by way of background in relation to the broad allegations made by Lieutenant General Nkwanazi. Can we perhaps deal specifically with the matter of that resulted in the arrest of Lieutenant General Kumalo? When, to your knowledge, did this saga begin, which resulted eventually in his arrest and subsequent appearance in court, and I believe also again today to amend or to relax his bail conditions?
Honourable Chair, before I proceed, I don't know if Honourable Songani still has she had her hand.
Yeah, we did not want to distract the SC. What do you want to do? Do you want to take a question first, or do you want to answer the SC?
Maybe she had a point to it that she would want to make.
Let's take Honourable Sangon.
No, thank you, Chair. No, it was a small point, just clarity. When the SC was reading, he started off saying in an affidavit deposed by General Kumalo. I wanted to make sure that it was
Yes.
General Mkwana's.
I concur, he did say that, Honorable Member,
Oh,
and I was going
sorry,
to ask.
Did
Yes.
I say Kumalo?
Yes, you said Kumalo. Oh, no. So it was Mkwana's.
It was Mkonazi, and it's an affidavit that is attached to his statement before the committee. Thank you.
Thank you, Honorable Chair. I will deal with the arrest of Lieutenant General Kumalo, but you made mention of quite a few things about the PKTT, and I would just, for purposes of completeness, indicate that IDEC is not aware of these cases that were made, be they by Mr. Matlala about theft, by Katitso Molefe, the ballistic case, or any other case that has been made against any of the PKTT members. They are not allegations that IDEC is looking at, and so I am, unfortunately, Chair, unable to provide this House with any information with relates or with regards to those matters. I'm not saying that there weren't cases. I also cannot comment on the validity of these cases and or not. That's not my place. What I can then indicate, Honorable Chair and members, is early in November 2024, IDEC did receive a Section 27 referral from Mr. Adams. To be clear, the ID herself hasn't met Mr. Adams, nor have I spoken to Mr. Adams, nor have I engaged Mr. Adams. And the reason for it is simple. Matters that are referred to IDEC must come through the head of investigations and or the two chief criminal investigators. That is how it works. And so I hadn't had any engagement. The Section 27 referral comes through in November. The investigators have engaged with Mr. Adams. His affidavit is taken. They then present an application for an authorization, as I've previously explained, as part of process, and the investigations are authorized. What was presented, Honorable Chair and members, is in terms of the collective matters that were referred by Mr. Adams, it wasn't one matter. As it stands in IDEC, they translate to 6 different matters. But the Section 28 referral looked at the collective complaint. And in terms of the collective complaint then looked at whether or not the bypassing of processes, the manipulation of processes and systems, the gratification in terms of the form of an employment, etc., fell within the ambit of state capture as we know it. Not the state capture per se of the State Capture Commission matters, but within the broader definition of what that capture meant. When we determined that the full ambit of those cases fall within that definition, the matters were then authorized. Currently, 2 matters are in court.
Can you just pause there and describe to us what defined the characteristics of what is regarded as capture, state capture?
So Chair, we have always, through the process of deciding whether or not, in the broader sense of the word, there is capture or state capture, we have looked within the ambit of the State Capture Commission report. And as I have referred in paragraph 37, if you would allow me to read, it says that according to the Zondo Commission,
Yes.
there it's the State Capture Commission report, state capture is a project where a group of actors with their network of collaborators systematically conspire to redirect sources for their own private gain. It's achieved by the improper influence of state appointments and procurement and manipulating the rules and procedures of government's decision-making, undermining oversight mechanisms, and weakening key state institutions like law enforcement and intelligence services. We then had to look at what those different allegations were. And I know that, and I do say in the affidavit, Honorable Chair and members, if you just take the Kumalo matter, just stand alone, Of course, the members of this House can say, what were you doing? That is a standalone matter. What is it doing in your mandate? It is in our mandate in terms of there is corruption, then there's the argument. But that's not serious corruption. But what is serious corruption? Does the manipulation and bypassing of processes, putting people in strategic appointments, isn't that what got us where it got us to in terms of state capture? And then you say, serious? Is serious money? Is serious the offense and the office bearers who are entrusted with these positions, who bypass these positions? And then let's just say, I lose that argument. The IDEC mandate can also look at fraud, which you would see in the charge sheet. It can look at issues of fraud, forgery, uttering theft, and any other matter that involves dishonesty. So as it stands alone, even on its own, and you take the corruption and you say to me, Madam IDEC, it's gone. There are still matters that fall within the ambit of IDEC for it to investigate and prosecute. But like I said, we first looked at the entirety of the Section 27. When we go to court, we've taken them on as the matters as they stand, or else we end up, Honourable Chair and members, with issues of misjoinder and charging people for different things where they shouldn't be in the same matter. And so we were able to then, as part of this process, start with matter one, which was the arrest of the Chief Financial Officer for the defeating and fraud. And then the second matter would therefore relate to the matter that we now discuss, which would be the arrest of Lieutenant General Khumalo and others.
And so there are 4 other matters.
There are 4 other matters that form part of the umbrella of matters that were the Section 27 referral that were sent through.
Honorable Malema.
Sorry, Madam, you were interrupted when you were trying to give us example of 2 cases. You said there are 2 cases and then you stopped there.
Honorable Malema, there were 2 cases that are already in court. The first case relates to the criminal allegations against Chief Financial Officer Major General Lushaba of Crime Intelligence. That was the first matter that was enrolled. And then a little over 2 weeks later, the matter relating to Lieutenant General Khumalo and the 6 other accused was enrolled. There are 4 other investigations that have yet to be enrolled because those investigations are not yet complete, but they arise out of that Section 27 referral. I hope I've provided clarity.
So, in those cases, do you find the name of General Mkhwanazi in there and the National Commissioner being part of the referrals that were sent to?
In terms of the Section 27 referral by Mr. Adams, I can tell you that I don't recall being briefed or seen in the referral itself for the authorization the name of General Mkhwanazi. And also with regards to the National Commissioner, I haven't seen his name other than, I guess, as the investigations progress. And to be very honest with you, Honorable Malema, I haven't had a briefing as of recent, so I cannot tell you about the National Commissioner and whether or not his name does appear.
But there was a story that there is prima facie evidence that is in your position against Mkhwanazi and the National Commissioner, and you are reluctant to charge. And if that is the case, will that not be defeating the end of justice if there is an overwhelming or prima facie evidence before you and you are reluctant to charge because of certain names, irrespective of who they are?
So to be clear, Honorable Chair and members, those allegations do not come out of the Section 27 referral. When I took over as the head, as the ID, there were already corruption matters that had initially fallen within the ambit of IPID. Those IPID investigators, when they were brought over to the ID at the time, came with their cases.
Are you okay, Honorable?
No, she was still responding to my question.
You will indicate if you are.
It's not me, it's the honorable member from Eastern Cape.
May I be allowed to finish, and then if Honorable Ngola will then be allowed to ask. Thank you, Chair. So those allegations do not arise out of the referral. They were corruption allegations that were initially reported at IPID. IDEC is not afraid to act. We can only act when we have sufficient evidence. And just because there's a complaint doesn't make a criminal charge. And that is why where we are at, Lieutenant General Mkwanazi and General Masemola have not been arrested for those matters.
Honorable Ngola.
Thanks, Chair. No, Chair, I was not trying to interrupt the honorable member from Sasha Limpopo. I was just indicating so that after he's done, you note me. I just want to get to one thing. Maybe the Advocate Johnson must take us to where does IDEC derive the arresting powers? Which law do they give them the arresting powers?
Honorable
Thank you. Chair, I want to call a point of order. You see, Honorable Malema and Honorable Ngola have been away from the ad hoc committee so long they've forgotten what a clarity-seeking question is. So they are starting new questions, and we need to wait until the evidence is led. Then they come back and they ask their questions. Please, Chairperson.
Okay. The part that says they have been away, they might have forgotten. I disagree with it. I sustain the latter part that says. But look, questions that emanate from the line of questioning by the evidence leader are acceptable. Yeah. Can we proceed in that way? If a question emanates from the line of questioning, I don't know the question about the mandate of IDEC, if it is related to what the SC was leading now. Yeah. May we proceed?
Chair, can you rule that my questions were not out of order? Being away after you have apologized doesn't mean you have stayed away from struggle.
Look, the away part does not belong here.
But my questions were in line with what the SC was asking.
I agree with that,
Thank you.
that part. That's why I say the part that both of you were away, let's not belabor it. SC, may we proceed?
Thank you, Honourable Chair. So the four other cases being investigated, they arise from the same Section 27 referral by Adams.
Sorry, Honorable Chair. I don't know if it looks like Honorable Ngola is still unhappy, but maybe if he, without me going into the detail, if Honorable Ngola will go and read Section 29A, subsection 1 and its various subsections of the National Prosecuting Authority Act, as well as the Act as amended in 2024, to deal with the question that he raised. Thank you, Chair.
You will come and explain that later when he is asking you. Now let's go to the SC.
Thank you, Honourable Chair. Advocate Johnson, yeah, I asked for you to confirm that the four pending cases being investigated, they arise from the same Section 27 referral by Mr. Adams.
That is correct, Honourable Chair.
And I know you wouldn't want to mention names, but at least you can tell us these four other matters pending and being investigated, do they involve the same or all or some of the 7 accused in the Khumalo matter, including Lieutenant General Khumalo?
I'm not going to go against my own principle that I espoused in this House. What I can say is those 4 matters relate to the crime intelligence environment and allegations of criminality in that environment.
Better be careful, your husband is also in that environment.
And if my husband does wrong, Honorable Chair and members, I think, and to be fair, let's deal with the question. There are consequences. One of the things I have always stood by, I'm not prepared to. He's an amazing husband, that's an aside. I'm not prepared to compromise my integrity or oath of office, not even for the husband, not at all.
So let's just deal with, you mentioned that you don't know, you haven't met Mr. Adams. You mentioned in your statement, though, that I'm looking at paragraph 44, that when he approached IDAC, he had already gone twice to the SAPS in the Western Cape and Gauteng provinces. We had open cases. And then you say, somewhat miraculously, these cases had disappeared. Now, do you have first-hand knowledge of this, or are you just conveying information that came to your knowledge at some point?
So, Chair, this came to my knowledge through my own investigators who had taken the Section 27 referral affidavit from Mr. Adams. So part of what he indicates is that when he received information, which he alleges was pushed under his door, which is part of the affidavit, that he opened cases in the Western Cape. He later opened cases in Gauteng. Nothing came of either or, and these matters then were referred to IDAC. However, what IDAC did find on the first arrest, the first matter,
Yeah, if you can conclude your answer.
is it okay, Honorable Skosana?
Conclude your answer, Advocate Johnson,
So,
and then Honorable Skosana will be given an opportunity.
Honorable Chair, I'm not sure if it is appropriate to raise. I know, I said, I do not know Mr. Adams. I've never met Mr. Adams. I've not spoken to him, but I have seen him on television. And it is somewhat of a challenge for me, ethically. We are discussing a criminal matter in which Mr. Adams is a complainant, and I do see that he is sitting in the House. What can happen later during a criminal trial, accused are allowed to say that their matter was unduly influenced by his presence. I'm merely raising it, and for the Chair and House to decide how you deal with it.
You don't know him, but you see him.
No, not knowing a person is one thing. I've seen his face on television.
Oh, okay. The face you see is the face you saw.
I wouldn't know whether it's a kilogram heavier or lighter, but yes, it's similar.
Okay. SC, how do you deal with that matter?
With Mr. Adams being in the house or in the room? I think we need to be consistent in the same way that we've dealt with some other honourable members remaining in the house, and despite being complainants in cases. I don't think, Advocate Johnson, there'd be any prejudice. Perhaps, I don't know, maybe getting a fright that you're seeing him here today. But apart from that, there's no prejudice to the case. He's a complainant in a matter.
To be clear, Honourable Chair, I didn't talk of prejudice to the state's case. we also protect the rights of accused persons. And I do not want accused to raise later on that certain details were discussed and the complainant thereof sat in a house where they didn't have representation and or were not present. I merely raised that ethical issue.
Well, you can go outside now, Ms. Johnson, and look at it on TV. It's going to make any difference.
You can take Honorable Kona Panat with you.
Honorable Malim.
Just to put it on record that Adams is not a member of this committee. He's a member of parliament. And like any other member of parliament, his rights are not withdrawn. He can attend any committee as a member of parliament. So this is a completely different space. Hence, before she took an oath, you have had to remind her that certain things that are done here may not even be used anywhere else outside this place. So it's for Adam's personal conscience that he left, which for me is good, but it should be put clear that he's not a member of our committee, he's a member of parliament, and it doesn't influence anything when it comes to how decisions are going to be made here. Thanks.
Honorable Skosana.
Thank you, Chair. I just wanted to make a follow-up question about the issue of Honorable Member Adams. That did Mr. Adams bring up a classified document in his report? If so, are you authorized to investigate a classified intelligence, and which specific section allows you to do so? Because according to the law, only the Inspector General of the Intelligence Office has the authority to investigate such matters.
Is that question based on the evidence that the SC is leading?
Yes.
Okay. Number one is that, yes, it's true that Mr. Adams is not a member of this committee. And number two is that he is not leaving the proceedings because it is a decision of the chair that he must leave. And number three, when questions are put to you, advocate, and in your conscience you have an understanding that it has an element to prejudice any person, you can always raise that to say, I believe that there is an element of prejudice in this question, and these are the reasons that I advance. Yeah, but when he left here, it's out of his own conscience. It's not because we have taken a decision that he must leave. Honorable Sangwen.
Thank you very much, Chairperson. And I know I don't have to, but I concur with your summary as well as what Honorable Malema had raised. Honorable Chair, I'm really not trying to be difficult, and I'm appealing to members, just in terms of the process and procedure we had established on this issue of the follow-up, the clarity-seeking questions. The questions that members are raising are excellent questions. They are very important. It's just that they're not for right now, including the question that Honorable Skosana raised. Let me tell you why I'm saying, Chair. In our very first meeting, I remember I attempted to do what the member was doing, right? I was interested in a point, wanted to pursue it. Honorable Malema corrected us, even made an example that you asked things like, no, is it this one? Who do you mean exactly? I did not hear that word, So if we could please maintain that, Chair, then when members have their time to ask questions, then any and every issue that they want to interrogate, they can do it at that point. I'm appealing, Chair. Otherwise, we won't finish leading the evidence. Thank you, Chair.
You talk about questions asked out of impatience. Okay. Honorable members, and I asked that question, Honorable Skosana, because I believe it's a question that can still be responded to later. But if you strongly feel that it must be answered now, I can concede to that.
Chair, I wanted clarity. It's no longer a question time form for me. Can you please answer now? Because we're on that matter of Adams about what Adams brought. So I just wanted to find out about
What
that.
is the clarity you seek? No, yes. What is the clarity you seek?
Must I repeat the question again?
Yeah, the clarity seeking question.
So must I repeat it again? Whether advocate through you, Chair. You want me to repeat myself?
Honorable Skosana, I did hear you.
Thank you.
May I proceed, Chair? I'm going to answer without going into a whole debate, and I accept, Honorable Member, you will come back with more questions when it is your turn. Safe to say, what the ID herself received was a Section 28 application based on a Section 27 referral. The investigators got an affidavit from Mr. Adams. But let's just say the ID was given a document purported to be classified. The ID is in possession of top secret clearance that therefore will allow me to look at those documents. However, before we do that, even with the SSA matters, Honorable Member, what we tend to do to err on the side of caution, we would indicate to the person giving us a document, can you rather declassify before you give us? But I did not have sight to any classified document. Thank you, Honorable Chair.
SC, we have 4 minutes left before the next break.
You want me to proceed, Honourable Chair?
If you are generous enough, you may say we break. And if you feel we can still do something in 4 minutes, you can say we're a nation at work for a better life for all.
Well, we're dealing with this important matter now, so it might be convenient to break at this point and to resume after lunch.
Honorable members, we are breaking, we are coming back at 14 hours. Good afternoon once again, honorable members. We should resume the proceedings. SC, Advocate Johnson, are you fine? Thank you so much.
Thank you, Honourable Chair, honourable members, and colleagues, and everyone present.
Chair,
Honorable Malim.
are we going to start without MK because it looks like there's a serious problem inside?
No, Honorable Malim, the meeting still has a quorum. You know, the meeting corrects once. Yeah.
New faces will come. Don't worry.
May we please allow the SC to continue?
Chair, can we talk about IDEC only today?
No, a matter was brought to my attention that when I don't see you returning, I must understand that that might have been your last appearance. Yes, SC, we have handed over to you. Are you done? Are you done, SC, with your questions?
No, Honourable Chair. I'm not done. May I continue?
Yeah?
Thank you.
Okay.
Thank you, Honourable Chair, honourable members. Advocate Johnson, we're dealing with the referral by Mr. Adams in terms of Section 27. And you, just to recap, you said that apart from seeing him on a television screen, you don't know Mr. Adams at all.
That is correct, Chair.
And you didn't receive the referral yourself when it was first referred to IDEC.
That is correct.
Just remind us again, what was the date of that referral?
The referral would have been in the second week of November 2024.
Okay. You're not aware of Mr. Adams also referring this matter to the National Commissioner
No, Chair,
or to the Minister?
No, Chair.
Either the Minister or the National Commissioner?
not at all.
And when, after the referral in November, when did the matter land on your desk? And what matter was that? By the time his referral landed on a desk, what was all contained in it? What work would have been done on it?
At the time I would have received it would have been around about the middle of December. But I had been informed before that that I will be getting a Section 28 application for consideration to authorize an investigation, as there had been a Section 27 referral by one Mr. Adams. But I didn't get any documents or a full briefing, so I would have received the application itself around about the middle of December. But the matter had come to IDAC by the second week of November already. That is an affidavit to the investigators in terms of the Section 27.
And when the matter landed on your desk in December, somewhere in December, was that for authorization to further investigate the matter?
That is correct, Chair.
And in the documents that were placed before you for consideration and your approval for further investigation, there would have been a reference to a Lieutenant General Khumalo.
Chair, what the document did is it summarizes the Section 27 referral, setting out some of the facts that were in the affidavit, as well as persons against whom criminal conduct is alleged. That is correct.
So at that stage, there would be allegations set out in the affidavit accompanying the referral.
That is correct. In this matter, it was.
And what was your, and in that referral, there was no mention, did you make a connection between Lieutenant General Khumalo and, of course, him being head of crime intelligence?
As head of crime intelligence, yes, because it talked to the head of crime intelligence. But if one is asking if there was any referral to the PKTT, no. It was Lieutenant General Khumalo. It was about CI officials, the head of CI. There's only one head, which would be Lieutenant General Khumalo.
Did it raise any red flags with you, any issues with you, that this is quite a significant matter with serious allegations against the head of our crime intelligence?
Not concerns. I was receiving a matter. There are many high-profile matters. There are many persons who hold high office that are implicated in many IDAC matters, those still under investigation and those that are in court. So it was looking at the allegations and looking at who might be implicated in those allegations. I didn't have a concern in the traditional sense of the word. I had to apply my mind to the matter, yes.
Did you, where's that?
The email, the first one. Below.
That one.
This is the one, and then this one. This is Adams, and then copying there to the National Commissioner.
Did you receive, there was an email that was sent to your office by the then Minister's Chief of Staff, Mr. Gabinde. That the matter had been referred to IDEC, and also a further, sorry, if I may just read it to you, it's why does the public service always have the date right at the bottom? It's on the 11th of November 2024. It's addressed to the investigating director, IDEC, referral and request for investigation in terms of Section 27. Attached, please find, for ease of reference, a copy of written correspondence addressed to the Honourable Minister of Police, Honourable Senzo Mkhunu, by Member of Parliament, Honourable Fadil Adams. The allegations contained therein implicate very senior members of the South African Police and are viewed in a serious light, and case dockets were registered as per the following case numbers. Then there's one Langplater case number and 3 Orlando case numbers. Due to the nature of the allegations made by the Honourable Fadil Adams, which seem to be quite sensitive and which contains allegations of criminal misconduct, this office requests the investigating director to consider investigating the same. Honourable Fadil Adams was advised by the office to await your decision in this regard, and it's signed by Mtoko Zizi Kabinde, Chief of Staff, 11 November 2024. Do you recall seeing?
Honourable Chair and members, yes, we did receive such a letter. IDEC didn't act on that letter because it's not a Section 27 referral. He wrote to us to consider and says it is a Section 27 referral. There is the person who's making the referral, Honourable Chair and members, which is how Section 27 reads, must depose to an affidavit. There was no affidavit. This was Mr. Nkabinde writing and alerting us to a matter. We were approached by Mr. Adams, and when we were approached by Mr. Adams, we then asked Mr. Adams to depose to a Section 27 affidavit. And so even though that letter talks to dockets, we didn't go and get those dockets at that stage because we didn't have a proper Section 27 referral. So we had to get a statement from Mr. Adams after Mr. Adams approached our office.
Did you respond to Chief of Staff Kabinde?
No, sir.
Why not?
At the time, I can't, other than the letter had come in, and I think it wasn't much long after that Adams would have engaged with the investigators. But at the time, I received the letter, and that was it. I didn't act on the letter because there wasn't anything to act on.
So, were you aware that the matter had also been referred to South African Police Services?
Only insofar as Mr. Adams, in his affidavit, indicated his initial report to a police station somewhere in the Western Cape, and then his reporting of same to a police station in Gauteng. That is the only SAPS references that IDEC is aware of.
So, if I may just, Honourable Chair, refer to, we asked earlier for an adjournment just to put together a further exhibit bundle of documents. Do you have it there, Ms. Johnson?
I have a document, Chair. At the top it says Annexure MK15 and a number 269 on the right-hand corner. And it is a set of documents.
Can you refer to the page with 283 at the top, and honourable members also, Chair?
Honorable Chair, if I may ask Council to just read what that letter would start with, because
No, I'm referring
many
just to
of them, sorry, I have a 2.8, and then I don't have anything after the 2.8s. There's no 2.81, 2.82, 2.83. So maybe if you just say what the top of that...
It appears to be cut off.
Yes.
Must be crime intelligence.
So maybe if you could just give us the heading of what that document would start with, Council, then I know which page I'm supposed to be
Maybe
on.
something. And before that, is there a document with a SEPS badge? Just before that. Before that document.
Maybe Tara, it's the next page of the complaints document with the heading complaints. And then it's the next page.
There is a document with a SAPS badge, and it purports to be
And
an
then-
email from the National Inspectorate Bopela HA Lieutenant Colonel. And then my next page with the 2.8 says NB,
And this is the
feedback
one
must
that's
reach
cut
the
off.
office.
Yeah. If you see at the top there, there's an email from Gabindi CM,
Yes,
dated Friday, 1 November.
at 9:04,
Yes,
I am there.
that's the document. So you'll see there that's an email from Chief of Staff in Kapinde, dated Friday, 1 November. Good morning, Major General Sipola. The Ministry has received this complaint from the Member of Parliament. In order for the Ministry to respond accordingly, please furnish this office with a report in responding to this complaint and the details of the investigating officer who was assigned to investigate these cases. Your report is expected on Monday, the 4th of November.
That's to the National Commissioner.
And at the bottom, you can see it's from a Sakina Frenchman, but it appears to be on behalf of, and you see on the following page, regards Honourable Fadil Adams. That's the complaint. You see that? So you're not aware that this complaint was being laid also with the Minister Mkhunu at the time, and in turn that he was referring it to the police?
Not at all, Honourable Chair.
Sorry, ma'am.
Not at all.
And this is also, yeah, okay, that's more comment. I'm not going to raise that with you. Now, if you should, right at the front of the bundle, there should be, it's called an information note, which is addressed to the National Commissioner. I'm afraid it's also cut off, but maybe some of you are lucky to have it recorded there as page 273.
The third page.
It would be the third page in the bundle.
Would that be an information note?
It's an information note addressed to the National Commissioner.
And above the information note, does it say SCS 19/11 of 2024 and?
Yes, Advocate.
I am there, Chair.
Yeah, thank you. And now it ends probably about 5-6 pages further on, and what should be page 280, and it's dated 30 July 2025, and it's signed by Lieutenant General Divisional Commissioner, Inspectorate P.A. Jacobs. You see that? Now,
See that?
this memo records the passage of this complaint by Honourable Adams and how it gets to the National Commissioner and eventually as I said, it concludes with the signature of General Jacobs. You'll see this is headed Complaint Against SAPS, Allegations of Corruption and Defeating the Ends of Justice. Complainant F. Adams. The purpose of the information note is to provide a response to the allegations that 1, the Division Inspectorate was complicit and irregular in the handling of a service complaint levelled by Mr. F. Adams, MP, and 2, to reflect on an averment that the Division Inspectorate irregularly handed 7 dockets to the Investigating Directorate Against Corruption, IDAC. So just to pause there, were those the dockets that would have been requested by the IDAC investigation team?
The dockets that were requested are those dockets. They were, however, requested by myself as the ID on a letter to the Divisional Commissioner Detectives, Lieutenant General Sentumule, given that as the Divisional Commissioner Detectives, I automatically and ordinarily assumed that any dockets to be found, or if they were at head office, would have been with the detective component, hence my writing to the head of detectives.
And when would that have been? Because you received the complaint also in early November, and you said that it landed on your desk for further investigation, authorization mid-December.
I will, when we do break, ask my office for a copy of the letter, but it would have been soon after the authorization of the matter. But I do recall having written to Lieutenant General Sentumule, and I recall her then ensuring that the dockets were received accordingly by IDAC.
And just while we're there, we'll come back to the information note, but did you subsequently request information from the National Commissioner himself and write to him yourself?
It is correct, Chair. Once the dockets were received,
so this is now in this second phase of the investigation?
Second phase,
Yeah.
the dockets are being referred to. We then request to get those dockets. Once the dockets were received, investigations commenced as the matter was authorized. And when we realized, or when the investigation team realized that there were documents that the investigation required, but they fell within the domain of crime intelligence, we then sought to rather subpoena those documents through the Office of the National Commissioner. He is the head of police, and the National Commissioner would have then had to indicate one of two things. Yes, I will adhere to the subpoena, which he did, or he could have said, I cannot allow for these documents to be made available to IDAC, upon which we would have had to consider what legal recourse, if any, we would have had. But we did serve it on him, given the nature of the environment from which we were seeking those documents.
And when would that have been?
Subject to correction, Chair, that would have been any time from January, February of 2025. We served various subpoenas as and when the investigation indicated the requirement of certain documents, and those documents were either within SAPS or crime intelligence, the relevant subpoenas were issued accordingly. So it wasn't one set of Section 28 subpoenas for documents. It is as and when the investigation highlighted the need to get certain documents from within the police domain.
So was it a request in a letter or was it a subpoena that was served on the National Commissioner?
We served a subpoena on the National Commissioner. I personally called the National Commissioner to indicate that given the sensitive nature of these matters and given the environment within which we say the documents are, it is a safeguard for the police and ourselves. We are going to subpoena the documents, and it is on that basis that we proceeded. So where one would ordinarily have written a letter, given that we wanted these for court-directed purposes, and I said when we want for court-directed purposes, we issue a subpoena. However, he is, after all, the National Police Commissioner, made the call to indicate. I also asked the Commissioner who would be the nodal point in his office that would be allowed to receive these subpoenas. And those discussions were had between him and myself telephonically, and I then conveyed to the team to go ahead and prepare the subpoenas for the documents we require.
Okay. So when he received the subpoena, your protocol had already indicated to him that he would be getting the subpoena?
Absolutely.
And so the National Commissioner would have been aware that the head of crime intelligence was being or is being investigated by IDEC.
That is so. In the issuing of a subpoena, you've got to set out the allegations, and the allegations will indicate that environment and the level of persons. And so the National Commissioner would, by virtue of just having a read of the subpoena, and because of what we were asking, would have known even if you didn't put the name.
Honorable Sangon.
Sorry, Chair, just a clarity-seeking question. Are we using documents and dockets interchangeably? So what were we subpoenaing? Was it getting the additional documents or the original dockets? Thanks.
Honorable Sangoni, the dockets we requested by way of letter from the Divisional Commissioner, Lieutenant General Sentumule. What we were requesting through the National Commissioner was documents that were not dockets, because we had the dockets. So it was documents and information by way of subpoena. Thank you.
You may proceed, sir.
Thank you. Thank you, Honourable Chair. And since this was sensitive information, documents that you were seeking from the National Commissioner, how were they obtained? How were they received? Were they brought to you? Did you fetch them? What happened?
I just would like to add one more point before I answer the question or respond, Council. I also indicated to the National Commissioner in that telephonic engagement that I do accept that it might be quite a lot of documents and or not knowing where they might be located. He might require more time. Now, the subpoena gives you a fixed number of days. I made it clear to the National Commissioner that should his office require more time to honor the subpoena, he was more than welcome to indicate so that the requisite extension of time could be granted. When the documents, the first set of documents, and the bulk of the documents were ready, the National Commissioner brought them himself in person to IDEC's offices. I wasn't aware that he was going to do that. I was informed by the investigating team on that morning that the National Commissioner was coming to IDEC. I, in fact, said, but I wasn't aware that National Commissioner is coming because there is protocol in how we receive persons of certain standing. I then informed my office that he was going to arrive. He brought the documents. So when I say he brought the documents were in boxes. He was accompanied by certain officials. The one official whom I do recall is Major General Marga van Rooyen, because she's a senior member at Legal Services. The both were invited to my office. We greeted. I did indicate to the National Commissioner, it was not necessary for you to bring these documents yourself. You could have sent them or we could have collected them. And the National Commissioner indicated that these are important documents and it is an important matter, and he therefore sought to bring them himself. I thanked him and had him and the people that accompanied him, together with the investigation team, leave my office so that the discussion around the documents, the adherence, whether in full or in part of the subpoena, and anything else be discussed outside of myself. So what was brought, I cannot indicate, but he did bring them personally.
So you personally didn't open the boxes or whatever?
Not at all. I had no sight of what was in the boxes. It's not my job to do. I have to leave it to the investigating team. Hence, after thanking the National Commissioner, I asked the National Commissioner, the legal officer, other members that accompanied him, and the members of IDEC to go to a different venue within the building so that that handover process and the comparison of what was requested in the subpoena vis-à-vis what was provided by the National Commissioner, that could have been done outside, and that was done.
Excuse me. So that would have been in January, February?
And that's why I say I speak under correction. The subpoenas would have gone out, started going out from January, February. There were subpoenas in March. I know there were subpoenas in April. But the first time documents were brought, the National Commissioner brought them.
And still with your process, I'll come back to the information note, because there appear to be parallel processes. So in terms of your process, what happened after these documents were brought by the National Commissioner to your office? They were then handed to your investigators. What happened next?
Honourable Chair, the investigators would then, having access to those documents, would have studied the documents and then put them in those relevant case files, bearing in mind that we had divided them into 6 different matters. So we didn't subpoena each matter and then wait for adherence to the subpoena and then go on with the next. It was a parallel, continued process. And based on the documents that were received, I know that the investigators and prosecutors indicated that there would be follow-up subpoenas because some of those documents were not complete in terms of there would have been other supporting documents that were required. So it was part of an investigative process to which, where I play no part, but which is part of what we do when we subpoena documents across the board. So even if we had to subpoena a cell phone service provider for documents for Mr. X, we always have to do this process. What did the subpoena request? Was it adhered to? Did we get the complete documents? Are they clear? Where do they fit? Do we need to ask for more? So that would have been the process.
And then after those documents were considered by the investigating team in relation to what appears to be 6 matters, when did the matter relating to Lieutenant General Khumalo and the other matter that you've also mentioned, when did that land on your desk for authorization?
The matters were already authorized. So the investigations were already authorized in December.
Well, maybe I'm referring to the prosecution and then the decision.
The prosecution engagements, Honourable Chair, commenced from May. I was getting briefings at the status of some of the investigations. And what they did is they worked out for themselves which matters they are able to get ready, and it depended on how much evidence was required for that matter. So the first matter was ready, and at the end of May, first week of June, I received the prosecution memo, received a briefing from the investigation and prosecution team, as is with all of the other matters, asked the necessary questions, made sure that they were comfortable with the decision, and then engaged the Director of Public Prosecutions, as we should, for the enrollment. 2 weeks later, and that would take us to around about the end of June, that then also happened with the matter wherein Lieutenant General Khumalo and 6 others were arrested.
And he was arrested in Just remind us of the date.
It was the 26th of June. It would be AJ1. Let me just be sure. It would have been the 26th of June, 2025, Chair.
6th of June 2025. Okay. You didn't, in terms of protocol, take it upon yourself to inform the National Commissioner that one of his most senior officers was going to be arrested? Or did you follow some other protocol involved when a very senior person is involved?
Correct, Chair. The protocol I follow, since I report to and am accountable in terms of my reporting to the National Director of Public Prosecutions, I did inform the National Director that the Head of Crime Intelligence, Lieutenant General Khumalo, and others would be arrested. I do not discuss the merits of the matter with the National Director, but I did indicate that in terms of the Section 27 referral, we had worked out those matters within the ambit of the definition of state capture, but that there were individual matters that dealt across the board with fraud, corruption, and or defeating, and this matter would be enrolled. We did the same, Chair, when it was the first matter that was to be enrolled as well. So each time I inform the National Director that there's going to be a matter that appears on the roll, and that is for all matters. I do not discuss the merits of the matter because I have the discretion as the ID, as do directors of public prosecutions, to institute prosecutions for and on behalf of the state.
Did you inform the National Commissioner?
I did not. I informed the National Director.
Okay. Now, did you inform Lieutenant General Khumalo?
We didn't inform him. When he was to be apprehended, he was informed what he was being apprehended for, that IDEC was in possession of J50 warrants of arrest. We asked that, well, the investigators asked that he kindly accompany them. Lieutenant General Khumalo was not placed in cuffs because he was returning from a trip and he was at the airport. It's a public place. One didn't seek to embarrass him. One merely sought to secure his attendance. And in fact, we did that for all of the other accused. They were called and told to please hand themselves over at the Brooklyn police station. These were senior members of the police who had been in their office. If we thought there was a risk that they could flee, one would have acted differently. But at the time, we didn't have a reasonable belief that that would happen. So when he was approached, there was no obstruction from himself. He got into the vehicle with the two IDEC investigators, and at all relevant times of that trip, even till it ended at the Brooklyn police station, his entire security entourage followed and knew where he was at all times. We did afford him that respect. We wanted to secure his attendance in court. That was the bottom line. One could have executed the warrant. We had a valid warrant. That was not the purpose of the exercise. The exercise was a method of securing his attendance together with the co-accused, and we treated all of them the same. So we didn't execute warrants on some and not on others. We called and asked them to hand themselves over.
So it sounds to me that unless you knew that, firstly, this is Lieutenant General Khumalo at the airport, secondly, that he was being accompanied by other police officers and it appears to be some kind of an arrest, it wouldn't have been evident that he was being apprehended, arrested. There were no handcuffs, nothing like that.
Not at all. And I do recall that Lieutenant General Mkhwanazi indicated there was a dramatic arrest. There was no dramatic arrest. There were just two IDEC investigators. They approached him, spoke to him, and he went to the car. Even at the time of the conversations, his security detail was right there. So he never placed us in any danger. We didn't place him in any danger. We really secured the attendance of an accused in court.
A bit different from your Scorpions experience.
Honorable Chair, if one takes note of how IDEC has been operating, you will find that there hasn't been media coverage unless there was some rogue journalist who hid behind a bush that I'm not aware of, but we do not do media-style arrests. We apprehend our accused. They appear in court. Of course, once accused persons appear in court, everyone would know about it. But we sought in all of our matters to be as circumspect as we can be. If there's one lesson IDEC took from how the DSO operated and how not to operate, it was that, which is why I also was at pains to indicate, Honorable Chair, that mentioning people's names without having certainty about the criminal allegations and evidence against them would become highly irresponsible.
Subsequently, Lieutenant General Kumalo appeared in court. Yep, he would have applied for bail. Did you oppose bail?
In terms of the schedule of the offense, you had to read the bail opposition affidavits, but we had agreed to an amount of bail.
So would IDEC's own prosecutors be present in court and actually present the case to the magistrate?
That is correct.
And would you, IDEC, have had anything to do with the bail conditions that were set by the presiding magistrate?
The investigator would depose to an affidavit. Prosecutor would read that out into the record and would ask for bail conditions. Yes, it's a prosecutor's job to deal with the bail application and bail conditions.
Now, you must please correct me if I've got it wrong, but the complaint seems to be that, or the effect of the bail conditions ultimately imposed was that Lieutenant General Kumalo and his co-accused would be prohibited from entering their offices, which effectively means that they couldn't do their job as crime intelligence officers. Just your comment on that, either if I got it right or wrong, or your comment.
The main interest we were weighing, at least the investigators and prosecutors, was the fact that several of our witnesses are from crime intelligence and in the employ of crime intelligence. And in the process of getting their statements, all had indicated that they had been victimized and was intimidated. What one sought to do, Honorable Chair, through the bail condition was prohibit the intimidation of witnesses. It had that unfortunate effect that the accused therefore could not return to their office. So we had to weigh the safety of the witnesses and the evidence that they would still have to give. So it wasn't per se directed at, we don't want you to do your work. It is the state's duty to protect their witnesses. And one of the conditions is, and we gave a list of names to the court, that these witnesses must not be contacted, etc., etc. That is normal. And part of the not going to the office was to ensure the safety of those. In fact, if you would allow me, Honorable Chair, in the one matter, the first matter, there was a time when General Lushaba went back to the office. And the witnesses were a flurry. We were inundated with calls about why were we, IDEC, so reckless about their lives that we didn't inform them. We were not aware he would go back to the office. It's not for me to comment on why he went to the office, but that was the effect of one person having gone to the office. So this is not a thumbsuck. It was the reality of witnesses who were in a very sensitive environment. And our duty is to the witness or witnesses.
So, as I understand or the reason for that particular bail condition was to protect the safety of witnesses, material witnesses, in the matter, in the prosecution of Lieutenant General Khumalo and others, and that they were fearing for their safety or lives. And that would be the reason barring them from entering those offices where the witnesses were. And you have one instance where one of the accused had actually gone back to the office, and it caused some, let's call it, consternation amongst some of these witnesses.
Absolutely, Honourable Chair. And we all know that they're currently in court applying for an amendment of the bail conditions. Should the court find in the favor of the accused, IDEC is going to have to decide with the National Police Commissioner, what do we do about our witnesses who find themselves in that environment? That would still be a concern. We'd have to honor the court judgment, but we have to protect our witnesses. And that would be a conversation to be had. So if the court decides against us, we'd respect the finding, but it wouldn't take away the initial reason why the condition was set or requested.
Now, this is obviously based on media reports, so you can ignore it or reject it or respond. But did they go back today to seek an amendment to their bail conditions, and did it relate to this issue of access?
That is correct, Honourable Chair. The application for the bail amendment did start some time ago. I think it started in October. But given the Madlanga Commission and the fact that Lieutenant General Khumalo had to testify, etc., the matter moved itself along. And today was the first agreed-to date for the court to continue to adjudicate. However, what also happened is, given the aspersions cast on the presiding officer who agreed to those conditions, the presiding officer decided, well, his name was being dragged through the mud, and so he would have to step down. And that caused, again, a disruption in terms of proceedings and process.
So did a new or newly appointed presiding officer, was he or she appointed today to hear the application for an amendment?
On the previous occasion, when the name of the presiding officer was made known at the Madlanga Commission of Inquiry, the presiding officer came into court, the original one, indicated that he would rather step down. He will also be applying to the commission to testify because of the aspersions cast on himself. There was an adjournment of the matter, and then another presiding officer was brought in to indicate that the matter is being postponed to today, and that today there would be a new presiding officer. However, the state applied for a motion application indicating that this would really waste time and is not in the interest of justice. This matter was already part heard, and that the original presiding officer who was dealing with the bail amendment should finish the matter. And that application was filed in the High Court. I'm not aware of what is happening in court at the moment. I'd be able to get feedback when we are done for the day to find out if a new presiding officer was in fact allowed to proceed, because it means everything starts from scratch, and that prejudices all the parties, state and defense included.
What consideration, if any, went into the fact that effectively our crime intelligence was now hamstrung by our top crime intelligence investigators being barred from office? They haven't been suspended from work, they haven't been dismissed, but because of a bail condition, they cannot perform their functions, which is so crucial to the criminal justice system.
What I can say, Honourable Chair and members, is they are not physically there, but they are still within the employ of SAPS. I have no doubt that they continue to work and or engage with colleagues, albeit not the witnesses that they were barred from engaging with. But crime intelligence is not hamstrung. There are acting persons that are carrying on with the job and have continued to do so, including a Major General who's acting as the Divisional Commissioner for Crime Intelligence. In all of those positions of the current accused, there are persons acting and the work continues. The National Commissioner himself has not indicated to IDAC that, unfortunately, crime intelligence, which is such a key component, cannot do its work. Rethink your stance. That has not happened.
And I suppose since COVID and so on, provided they were also barred from accessing information online, that presumably is such an important component, is having access. Obviously, they've got restricted access and passwords and stuff like that, that you and I can't access, but that remains in place.
Unless
is that
someone
not the
can
case,
tell me otherwise, I do believe it remains in place. I do believe that they, not I do believe, I am aware that crime intelligence officials, and this was reported to us by our witnesses, do meet with the Divisional Commissioner, Lieutenant General Khumalo. So people can leave that office. There's nothing that precludes the Divisional Commissioner from engaging his staff, from doing work, but they are acting, that notwithstanding. So it's the physical location because of the security of witnesses. So I think it would be rather disingenuous, Chair, to say that nothing happens at CI or that they are not having any insight and input into what is going on in crime intelligence currently.
So there's still physical meetings outside of the office where the witnesses or potential material witnesses are?
Yes, our witnesses have indicated that there are officials from crime intelligence, that head office, where Lieutenant General Khumalo and the co-accused have been barred from entering. Members leave that office and meet them elsewhere. They get feedback. They have engagements. And these would almost invariably are some of those who are acting. So nothing is lost. Of course, I wouldn't want to be barred from my office. And so I accept that it was an unfortunate consequence of wanting to protect the witnesses. But that was the only reason for asking that they do not report physically to that actual head office.
Okay. Now, the criticism, I think we've read it out to you earlier from Lieutenant General Kunazi, was that why would you want to turn this into a big case, corruption case, when it's simply about the appointment of a person within SEPS. Now, I know that you are limited in terms of what detail you can give us. But can you give us some high-level indicators, factors that arise from the investigation into this case and which satisfied you, obviously it must have satisfied you, that there are reasonable prospects of a successful prosecution for corruption and fraud in this matter? There's been some interference with your microphone.
Advocate? Yeah, no, we just wanted to bring it to your attention that your mic was off.
Thank you, Chair. Maybe it's that part of the afternoon. Although I know I'm going to be here long hours. So when we get to the affidavit, Honourable Chair and members, we have discussed from page 13, paragraph 33, about the allegations against Lieutenant General Khumalo and his co-accused, why we thought in paragraph 37 that looking at the cumulative effect of the Section 27 referrals from Mr. Adams, that they amounted to state capture, and then delved into the individual matter. And so in terms of the individual matter, we indicate in terms of AJ1, which is attached here too. And I think if the Chair and members would allow me.
AJ1 is the charge sheet.
The charge sheet. The charge sheet, AJ1, if... charge sheets like a lot of English, but if one goes to, at the bottom of the page, it says page 7, the top of the page is paragraph 12. But if one goes through page 7, page 8, up to the top of page 9, which stops at 12.15, which is why I chose to attach the charge sheet, sets out, in essence... Sorry, Chair.
Advocate Johnson, just, well, for me too and for the honourable members, there is, AJ1 starts with what is called the charge sheet.
Yes.
But then it's
all the court appearances.
Then there's
and bail receipts.
And then there's another
document
that
says charge sheet.
Yes.
That is the document, sorry, Chair,
which names the accused and which gives a summary
of the charges.
Yeah, that and when you refer to the pages, it's at the bottom.
It is at the bottom of that document.
Thank you.
Sorry, thank you, Chair. And it is attached so that it indicates throughout the document who the accused are. It sets out the provisions of the Corruption Act, but more pertinently then, from page 7 up to the top of page 9, Honourable Chair and members, it sets out what the state alleges that the accused collectively did and did not do. And what it talks to is non-compliance with, at paragraph 12.3, the National SAPS instruction in summary 11 of 2017, which deals with the appointments to posts in the SMS, where it sets out appropriate managerial experience, competence, and suitable, which means suitability of candidate, amongst other relevant factors to be considered by the selection panels. 12.4, that the selection panel was chosen by accused 1, and it comprised of accused 1, which is Lieutenant General Khumalo, as the chairperson, and other panel members, which were the co-accused. And if we can go to paragraph 12.7, so that I don't waste time, it was discovered that accused 1 and 5 accused 5 being one Sydney Zwelithini Gabela, and I can mention the name only because it is there in the charge sheet, which is a public document, are well known to each other, as is evident because accused 1, in applying for his security clearance, had the person as a reference. And we say that so that throughout you are able to see how the accused grouped themselves in a manner that sought to circumvent the processes. And by putting themselves in a specific grouping, they knew what they wanted to achieve. They knew which person they wanted must get the post, and that is what the witnesses will tell us. 12.8, accused 1, 2, 3, 4, and 5, acting in concert, shortlisted 5 candidates, 2 who were from within TSS, which is the crime intelligence environment, 3 from outside SAPS. And then they seek to do a few things, and I'll only mention one or two, but accused 1, 2, 3, 4, and 5 made misrepresentations about some of the candidates' knowledge, skill, and experience, and misrepresented in their report for the recommendations that all 5 candidates meet the requirements of the post. In fact, at 12:12, accused 7 submitted false and misleading information in her application and curriculum vitae. And 12:13, misrepresentations were also made by the accused with regards to the vetting application by accused number 7, resulting in her getting a security clearance she was not qualified to get. And at 12:14, accused 1 to 6 abused the authority vested in them by willfully disregarding and not complying with the SAP's National Instruction 10 of 2017, and in concert awarded a gratification as per the definition of gratification in the Corruption Act, which talks to a form of employment, to accused 7 in the form of employment without just and reasonable cause at the expense of other duly qualified, experienced, and skilled senior officers of SAPS. So when the panel was put together...
And just for the record, this is a public document, and obviously Lieutenant General Kumalo and all the other accused, they're in possession of this document. They know exactly what
That is correct.
the charges and the basis for the charges are.
That is correct, and that's the only reason I am able to read what I read into the record. And to then perhaps surmise that that is the gist of it, is they group themselves in a way to achieve a particular agenda, which agenda was to gratify Brigadier Mokwele with the post she was neither qualified nor had the requisite experience for, because she needed to be placed in a strategic position. And in placing her in that strategic position, it then indebted her to the accused for whatever they required in the future. And that comes in the other cases in terms of the other investigations that we are continuing to investigate.
What role would that person play if appointed?
So that
within
person
crime
would be
intelligence?
the head of the technical services. And the technical services is quite an important program for crime intelligence. It is where all covert work is done, where instructions for interception and monitoring goes through, where the procurement of devices, listening devices, interception devices are procured. The big procurement items happen here. And so you would need someone here who is not going to question you for that which you want to do. And it wasn't so previously in terms of, well, let me backtrack. Not to the knowledge of IDEC was someone previously in this position that was able to be compliant with what any divisional commissioner would have wanted. In all of the investigations, Honorable Chair, TSS has not been the subject of any criminal investigations done either in my time at the DSO, my broader time with the NPA, or even at IDEC till this matter. They really remained a very closed, covert technical environment.
Yeah. Now, let's get back to the information note now that we have that background and context which resulted in the arrest of Lieutenant General Kumalo and his co-accused and their appearance in court. From the information note, you'll see that there were allegations that arose from the complaint by Mr. Adams, a Member of Parliament. But then there's also a complaint about the averment that the Division Inspectorate irregularly handed over 7 dockets to the investigating Directorate, IDEC. Were you aware that there was such a complaint?
No, Chair. What had happened is when we received the referral, we needed to find the dockets. Hence, I indicated I wrote to Divisional Commissioner Lieutenant General Sentumule. We also informed her that we had heard, but had no confirmation, that these dockets were with the inspectorate. In fact, General Sentumule indicated, but why would they be there? And I said, General, I don't have answers. Kindly indicate whether or not we can access those dockets or get those dockets. General Sentumule did respond, and the dockets were handed over from the inspectorate. They were handed over to IDAC. And if you look at the document, Honorable Chair, that Council referred me to, I mean, the document Council referred me to had a report from Lieutenant General Jacobs. If I could just find my place.
You're looking for the end of the first information note.
Yes.
Yeah, you're looking for the conclusion
The conclusion.
that
And
is signed off. It's about 5-6 pages.
But the gist of it, as I have in my recollection to the National Commissioner, he says there was nothing untoward in the obtaining of the documents,
And where is that?
in the obtaining of, I correct myself, Honorable Sangoni, in the obtaining of the dockets from the inspectorate.
Yeah.
I just want to find
That,
it.
that,
I
that's the
remember I marked it.
conclusion. Yeah.
That is his, and that is the person who had those dockets.
In fact,
And his, I
Mr.
did
Noy,
find it, if I may. It
there
says,
is actually, yeah. This first information note, Honourable Chair, Honourable Members, is a summary of other documents that's annexed to this note. And if you, there's a document, it's in my bundle, it's marked page 289, Annexure 3. So it's about 10, 11, 12 pages from the
okay, sorry, Chair, the one you refer to now is
289 at the top right, marked Annexure 3, SCS 20/11/2024.
I have that.
Information note to the Divisional Commissioner, Legal Services, because this matter was referred on advice by the National Commissioner to Legal Services. And then there's input here from Lieutenant General Jacobs on the 20th of November relating to the complaint. And it's for legal advice, for an legal opinion of criminal dockets opened by the complainant. And you'll see a summary there that he opened in the background section 3 criminal dockets in Cape Town Central SAPS, but has learned that, quote, there has been interference from the SAPS provincial office. He thereafter opened 3 criminal dockets at Orlando SAPS, Gauteng, but it's also learned that there's been interference from the SAPS provincial office. The National Commissioner has instructed that the report is provided in terms of the allegations that the SAPS is derailing the criminal allegations levelled by the complainant. A report was compiled wherein the allegation that there has been interference from both provincial offices and were reported to be unfounded. It was also reported that this office is in possession of the 6 dockets opened by the complainant. And then the memo discusses these claims. The criminal allegations in the 6 cases which are opened are levelled against Lieutenant General Kumalo, Major General Lushaba, Major General Madondo, and Brigadier Ngube, and are centred on 4 specific matters, namely abuse of the Secret Services account, cover-up of a criminal incident linked to Valeria, failure to address Major General Madondo's results of the polygraph examination, wherein 2 incidents of tax evasion were uncovered, practices of nepotism. Then paragraph 3.3, as part of the protocols to address service complaints, an affidavit is obtained from the complainant. Colonel Philip of this office was tasked to obtain the affidavit. However, after numerous attempts, it seems as if the complainant is evading the request. That's now a reference to
Mr. Adams.
Honourable Member Adams. Then there's a recommendation, and a recommendation due to the sensitive nature of the allegations, which has been widely announced by the complainant. It is imperative that before any criminal investigation is launched, your office peruse the affidavits to provide a legal opinion on whether the elements of a crime exist and advise on the way forward. So that was on the 20th of November 2011. Then if we come back to the information note at the front, we'll see the role of the inspectorate is discussed on the second page. The findings of the service complaint investigation, those are the 4 dockets, the one in, 4 of Orlando, opened in Orlando, 3 Cape Town, 4 Cape Town dockets, case numbers. And then again at 4.2, various attempts were made to conduct an interview with Mr. Fadil Adams, MP, but due to the complainant's schedule, no appointment could be secured. The purpose of the requested appointment was to obtain an affidavit in terms of the allegations and determine if information alluded to in the affidavits contained criminal dockets, in the criminal dockets, was in possession of the complainant. Colonel Phillips submitted an affidavit to support the attempts made to secure the appointments. Then a report was compiled. Then at 4.4, the 6 above-mentioned dockets were provided to the Division Legal Services to provide a legal opinion on whether the elements of crime exist and advise on the way forward. Then at 4.5, an extract of the report received from Legal Services indicated the current information contained in the dockets is scanty and too vague to formulate charges against any suspects. As a result, Legal Services is unable to confirm that the required elements of any offence are contained in the docket. Then in Annexure 4, which is also at page 293 for those who have the paginated bundle. It's 293 Annexure 4. Have you got it there?
I do, Chair.
And this legal opinion is dated the 11th of December 2024. Quite a few things happened in December 2024 with him. But so you'll see, and right at the end on page 296, paragraph 13, the current information contained in the dockets is scanty and too vague to formulate charges against any suspects. As a result, Legal Services is unable to confirm that the required elements of any offence are contained in the dockets. So just at random, I'm sure honourable members will pick up on some of the detail. For example, at 3.4 on page 294, no details are provided regarding the identity of the friends and family members of Lieutenant General Kumalo who were allegedly appointed in the division. This would at least have enabled the investigation into the allegations. Neither the particulars or statements of senior members of the service who were allegedly instructed to ensure that Valeria case number so-and-so is not investigated, nor the statement of a sex worker are filed in these dockets. In Cape Town case number 1651 and Valeria case 403, the complainant alleges that Major General Madondo failed a polygraph examination in July 2024, whereafter the head of vetting, Brigadier Ngube, was tasked to ensure that the matter would not be addressed or investigated. The complainant does not reveal the identity of the person who allegedly tasked Brigadier Ngube not to invest the failed polygraph. And so it goes on and results then in the conclusion that is reached. And if we then go back to the front to the information note, we'll see that that following a process followed that the matter shouldn't go any further. Advocate Johnson, so one, your response, there appears to have been some parallel investigation, and two, that investigation contrasts markedly with the IDAC investigation, and it records that there seems to be no basis to proceed any further into the allegations of the Honourable Mr. Adams. I suppose an immediate concern would be that they also failed to secure him for an interview, and the opinion seems to be based squarely on what was contained in the dockets, and they say the information was scanty and so on.
So, Chair, the IDAC was not aware of these processes that I alluded to in the entire MK15 and all of its annexures and attachments. Because when IDAC requested the dockets through the office of Lieutenant General Sentomule, if this, and I'm not saying that this didn't happen, what would have made sense if IDAC was informed that they should please wait, there is a process to deal with this matter, given that there is a complaint that has been escalated to the Office of the National Commissioner. Of course, we would have waited. We were not informed that there was a process to look at the allegations and or the unhappiness of Mr. Adams. Not at all. The dockets were handed over. And it is so. Those dockets, in all likelihood, in the form that they were in at the South African Police Services, were scanned. And they were unable to apply, or well, they applied their minds, but could not come up with the requisite criminal charges. I'm not disputing that. But that must be borne out by the fact that for whatever reason, and the attempts they made, or the kinds of attempts they made, Honourable Chair, they did not secure an audience with Mr. Adams. IDAC was able to secure an audience with Mr. Adams when he referred the matter in terms of Section 27. IDAC was able to sit with him, to take his affidavit, and to fully understand the allegations that he was making. That was an opportunity the police did not get. I accept that if they got that opportunity and or asked for that opportunity and went ahead with it, there's a real likelihood those cases would not have ended up in the IDEC space because the police would have done their work. So I'm not blaming anybody. I'm just saying we were not aware of that process. And I would, honestly, in fairness to the colleagues at SEPS, one would have expected them to bring it to IDEC's attention, that they were vested in dealing with this complaint.
Honorable Sangweni.
Sorry, can I just confirm what is the date that on which Mr. Adams referred the matter to IDEC, firstly, and then secondly, the charge against accused 1 to 6. I know that 7 has an additional charge of corruption, 1 to 6. Thank you, Chair.
Sorry, Chair, if I may just ask for clarity, Honorable Sangoni, you are asking in terms of the referral made by Adams, what were the allegations he made against those accused?
No, the date on which he made the referral. Thanks.
I speak under correction, and when we get a break, I'll get the exact date, but it would have been between the 11th and the 20th of November.
What is General Khumalo charged with?
In the charge sheet which is attached, General Khumalo is charged with corruption for the gratification of the employment position, and then there are fraud charges as well that are preferred against the general and the accused.
Honorable Mwango, Honorable Skwasana.
Well, thank you, Honorable Chairperson. Good afternoon, Advocate. I'm just wanting to get some clarity here that the information contained in the annexure document actually gives us a process that actually had been undertaken by the police after they had actually received is it the dockets? I don't know whether it's the dockets from Mr. Adams. So it actually outlines the processes. Now, in the evidence here that is presented to us, the documents are actually reported to have disappeared. In the light of what actually is contained here, would you still say that the documents had disappeared?
Sorry, Chair, I seek clarity. I'm just slightly confused about what documents do you refer to, Honourable Member?
I mean, I don't know whether it is, you guys call it dockets.
The dockets, Honourable Member.
Yes,
Yes.
Dockets, yes. In your statement, in your evidence in chief, you are actually saying that those dockets were missing. Nobody knew where they were. And then here in this annexure, the annexure is actually outlining the process that indeed these dockets were being attended to in November and right up to December. So my question is, would you still maintain that the dockets had disappeared, as you have actually said in your evidence?
Thank you, Honourable Member. What is in my affidavit is what is reported to us by Mr. Adams, that he had opened cases in the Western Cape, those dockets disappeared. I used the words that the person used, that he opened dockets in Gauteng and they disappeared. What I did say in an earlier response just now was, IDEC was not aware of the process that was followed as per MK15. So how these got there, we are not aware. But what we did become aware of is when he came to Gauteng, we asked the Divisional Commissioner Detectives that we would like to know if these dockets are there and can we have access to those dockets. Given that they were then, as I now know, were busy with these, of course they had those dockets. But we didn't know where those dockets were, and the witness, Mr. Adams, the complainant, sorry, indicated that the dockets were missing. When those dockets were handed to us, we were handed dockets with Valeria CARES numbers and one Langlaagte CARES number, and those were the dockets that we then had. But those were the dockets that they had and gave to us. We didn't know that they had them till we wrote and asked for them, but that is what he said, Honourable Member, that the dockets were missing.
Through you, Chair, should we actually believe that the dockets were missing or had disappeared? Should we actually be still saying that the dockets had disappeared?
Honourable Member, I give it from the context of what was referred to us and what the complainant indicated. When we had the dockets, we can no longer say the dockets are not there. Those are the dockets that we were given by the head of detectives. So in his initial report, he said the dockets are missing. So when we were given the later information, we were able to ask for. So no, we can't say the dockets are still missing. We now have the dockets because the head of detectives provided us with those dockets.
Ngola and then Matthijs.
Thanks, Chair. In the same docket kind of questioning. Mr. Adams opens a case in Cape Town. 2 days later, Mr. Adams opens a case in Gauteng. When did he lodge a complaint with IDEC? And when did IDEC receive the dockets? Thanks, Chair.
Thank you, Honourable Ngola. He referred the matter to IDEC in the middle of November, and IDEC only requested and received the dockets after that. I indicated when we take a break, I will make sure that I get a copy of that letter written to General Sentomole to indicate that we were requesting the dockets. So he registered dockets. When you look at the CARES numbers, they say CARES something stroke 10. So he registered his dockets in October, but he only approached IDEC in the middle of November, and we got the dockets after the referral.
So Mr. Adams' evidence is that in month end October, he registered cases, but already, which is a probably about 17 days, 15 days, his evidence is that dockets were missing in between those days.
That is what he referred.
Okay.
Honourable Matthijs.
Thank you, Chair. Advocate, it's a bit bizarre that you don't have the exact dates even in your affidavit, or in your statement rather, but we have here the 29th of October was when Honourable Adams opened the case in Western Cape. Then it's the 31st of October when he travelled to Gauteng. Then on the 1st, he writes to the minister, and then you get a letter on the 11th of November. So it's all in a space of 14 days. Does that make sense to you?
So
14 days that it landed up with you to intervene.
Honourable Chair and Member, I understand what you're saying. On the face of it, it looks as though things were rushed. We cannot determine the sequence that he chose to follow. But when he did come to IDEC to refer the matter, we dealt with the matter at the time. I accept that it doesn't look kosher, but that is what he did. I cannot comment on why he followed the timeline that he did. And that is why I go back to, if the police had indicated they were running a process as per MK15, we would have stood back and allowed that process to run. It was not in our interest to be running with the matter while they ran with the matter.
So the question wasn't talking so much about the process of of Adams, of Honorable Adams. It's about that when you finally got hold of it, that this happened so quickly. So that just didn't raise any awareness that within 14 days you have something, and the fact that he said dockets are missing and they actually weren't missing.
I take the point, Honorable Mates. I can't differ from your answer, except we received a complaint, we acted on the complaint in the time that we acted on the complaint.
Honorable Sangon.
Thank you, Chair. Sorry, Advocate Johnson, would the affidavit that Mr. Honorable Adams would have had to depose as part of the Section 27, would that be a public document? Would we be able to be furnished with that document?
If the chair can put his...
Yeah, respond to the question and then we'll go to the next.
Your microphone is on, so I couldn't
Okay.
press the... Sorry, Chair. The document is not a public document. If it was, I would have brought the document with it. It forms part of the investigation and forms part of that process. It's not a document that has been disclosed.
Can I follow up, Chair? So this matter is in court. Would it not be part of the court papers and therefore a public document?
They aren't part of the court papers.
Honorable Malim, are you fine? Okay. SC, I think we are ready to proceed.
Thank you. Advocate Johnson, did you have any interaction during the course of 2024, after July 2024, and in particular around November 2024, December 2024, with Minister Mkhunu and or his Chief of Staff?
Not that I can recall. I hadn't had an engagement.
Not that you can recall, or is it possible that you may have?
I remember that, not with Minister Mkhunu, no. I hadn't spoken to his Chief of Staff.
So,
not from my own recollection.
And the only contact, is it your evidence, the only contact you had with Minister Mkhunu's office was that letter you received from Chief of Staff in Kabinde?
There had been occasion for IDEC to write to the minister. There had been a complaint from his Chief of Staff about a member of IDEC. And as the head of IDEC, we asked the Chief of Staff that the allegation he makes is serious. He must depose to an affidavit or a statement so that that matter can be referred to be investigated. That was the level of engagement. The Chief of Staff sought not to engage. He refused to depose to an affidavit. And what the ID did was write a letter to the Minister of Police, Minister Mkhunu, indicating its displeasure that the Chief of Staff raises an issue with one of its investigators directly with the ID, refuses to make a statement. It is an issue of integrity of the investigator and of IDEC, and that can this matter please be dealt with, and can he kindly implore on the Chief of Staff who made these allegations to please depose to an affidavit. The Minister never replied to me, and to date, the Chief of Staff also did not depose to a statement where he made allegations against one of the investigators at IDEC. That would have been the most engagement I had with them.
Did you have any interaction with Lieutenant General Mkhwanazi during that period?
November, December?
No, yeah, in 2024, and especially towards the end of the year, November, December.
No. I'm sure that after the referral by Mr. Adams, my investigators, over the course of the investigations, did engage with Lieutenant General Mkhwanazi. I did not. The only time I did engage was then now in 2025 when the General himself had called me about assisting with something. And the last conversation with him was on the 2nd of July, 2025.
The 7th of July.
Was on the 2nd to
The 2nd.
July, 2025.
And what was that about?
Lieutenant General Mkhwanazi had called. He indicated that there is someone he knows at Correctional Services in KZN, and can I kindly engage with the person? There is something that they want to report or raise. He says, I don't know the details. I indicated, General, kindly send us the contact details so that IDEC can engage. Lieutenant General Mkhwanazi on a WhatsApp sent the contact details of the person that he was requesting we make contact, IDEC make contact with. I said, not a problem, General, we will deal with it. He said, thank you, sent me a picture with the police salute, and that was it. I didn't, nor did my office, in terms of the investigators. We didn't get an opportunity to engage because once the media expose of the 6th of July, I paused to wonder why we were asked to make contact with this person. And I've subsequently learned that that person is, in fact, subject to investigations for corruption. So at the time, I didn't know who it was. After the 6th July expose, I sought to look and find out who this person is that we were being asked to contact, given the allegations made by General Mkhwanazi about IDEC and the ID.
So just explain to us, what is the connection between this person that Lieutenant General Mkhwanazi wants you to make contact with and his involvement in a corruption case? Is it a case that you were investigating as IDEC or a case that the police was investigating?
Honorable Chair, I had no idea who the person was. General only indicated that this person had an issue that he wanted to discuss or escalate. He said, I'm not sure of what the issue is. I asked him to send me the contact details. We didn't speak to the person, but after the 6th July expose, I sought to look at who is this person we were supposed to contact, and it turns out that this is a person implicated in corruption.
But what case of corruption?
So this is a person that is implicated in the in allegations of corruption with Bosasa in his time as the Correctional Services Commissioner for KwaZulu-Natal. That is the allegation.
The Zondo Bosasa or something?
The Zondo Bosasa, yes.
And he wanted you to contact that person?
Yes, but what he wanted, I don't know that he knew, I want to be honest. I really don't know if he knew what the person was going to say. I don't know if he knew what the person is involved in. I cannot make that kind of deduction. But after the 6th July media expose, I sought to step back because I couldn't understand why he would have talked to me on the 2nd of July, yet went ahead and made the allegations he made as he did on the 6th of July. I sought to step back from that matter.
So I don't think it's rocket science to deduce that you must have been quite shocked when you heard his allegations on the 6th of July, having had contact with Lieutenant General Mkhwanazi on the 2nd of July, actually asking you to do something.
That is correct, Chair.
Now, just going back to the legal opinion that was provided to the National Commissioner, it was also dated 11 December 2024. And it's clear from here that they say, obviously, Honourable Adams' allegations are scanty and so on, but they do say it requires to be properly investigated and prosecuted. However, it also requires that resources should not be wasted and suspects should not be subjected to persecution based on unsubstantiated allegations. They acknowledged the seriousness of the allegations. They said, while these allegations made by the complainant are serious in nature, they are unsubstantiated at this stage. The complainant's statements can be described as vague accusations rather than an account of factual details that fall within the complainant's personal knowledge. And then they say the current information in the dockets is scanty and too vague to formulate charges against any suspects. As a result, legal service is unable to confirm the required elements of any offence. Any offence are contained in the dockets. But subsequently, you or IDEC, the investigators, did engage with the allegations, obviously interviewed witnesses, gathered further information, and they presumably satisfied that there's a case to answer.
That is correct, Chair, insofar as the two cases that are now enrolled. The other cases must still be assessed once those investigations are complete, and I cannot tell this House that there would be sufficient evidence or insufficient evidence. We'd have to adjudicate those matters on the evidence based on the investigations. So what would happen with those cases, I am unable to indicate. Unlike with the first two, we were able to finish those investigations because they were much easier in terms of the allegations. The other allegations are a bit more in-depth and need a lot more investigation than what was in the two initially enrolled cases.
Now, a standard question in our inquiry. Do you know Kat Matlala? Do you know Brown Mkhotsi? Have you got their names or numbers on your mobile telephone?
No, I don't know any of them and got to know of them from what is in the media reports.
Were you aware that Mr. Molefi's place was raided on the 6th of December 2024?
No. After the fact, yes, as it now plays itself out in the media through the Commission.
Because the narrative is that what triggered this whole train of events is Molefi's, the raid, his arrest on the 6th of December in Gauteng. PKTT is also involved in that operation. And then you have the directive of the 31st of December 2024 issued by the Minister. And then there is of course, terminating PKTT immediately, and there's an issue about that. But there's the dockets are then sought very early in January by General Sabia, and there's a whole trail of events.
Honourable Chair, it is rather unfortunate that were the conclusions that were sought to be drawn. IDEC received a referral from Mr. Adams. We continued with that investigation. In February, we received a referral from the South African Police Services into the tender irregularities of Kat Matlala. We proceeded with that investigation. If it hadn't played itself out in the media space at the time about his devices being seized, we would have carried on with our investigation till the investigation dictated a need to conduct a search and seizure in terms of a cyber warrant and then in terms of a normal warrant for documents. What their allegations and involvement are in other criminal matters, who's investigating those matters, are not of interest to IDEC, nor were they within the purview of IDEC. And the only way we came to know that the PKTT was even involved in the Matlala matter was the National Commissioner who directed that the two cell phones that were seized from Matlala were with Lieutenant General Khumalo's team, and that he had arranged and facilitated that those would be brought to IDEC and the cyber expert for download. That is as far as the knowledge is concerned. Everything else that we do know about the PKTT has played itself out as it has in the media. Be it the letter, be it the request for dockets, why they were asked, when they were asked, were not within our purview, and it has nothing to do with IDEC. And we had no right or reason to be involved in any of those. And if I could just say one final thing, if the police had not referred Honourable Chair and members on the 16th of February 2025, if they had not referred the 360 million rand tendered to IDEC, IDEC would not have had any matter against Kat Matlala. If they chose to refer it to the DPCI as an example, we would have had nothing to do with any investigation into Kat Matlala, and we don't have investigations against the PKTT and or Mr. Molefe or anyone else that is mentioned as part of that group.
So are you still investigating the Kat Matlala allegation about the tender?
Only the tender, yes. The 360 million rand SAPS tender awarded to Medicare 24. That is the investigation, not anything else.
Just to place it on the record, I'm just looking at the Minister Mkunu's affidavit that he deposed to in these proceedings. He says at paragraph 79 on page 34 for the record that shortly after he assumed office, that would have been in July 2024, he received reports of abuse of power by the NK, he calls it the KTT. These individuals had either been part of or were still part of the NPKTT. These are all events that he says informed his decision of the 31st of December. They have indicated their willingness to come and testify before the ad hoc committee should they be required. Although they are willing to assist, they have, however, raised issues of security, and that I leave to the ad hoc committee to decide. He then refers to a letter on the 3rd of August 2024 that he wrote to the Inspector General, then who is now suspended, of Intelligence, Mr. Imtiaz Fazal, requesting an investigation, and also in allegations made by Ms. Patricia Mashale. I don't know if you know her or heard of her, Ms. Patricia Mashale.
I have heard of her in the media space because she does make herself known in that space, but not in any other context.